Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Just in my rehearsal room. Hold on, 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 everybody hold on, hold on. Hold on, hold on, hold on. Robert is coming home. He's coming home. Hold on, everybody hold on. Robert is coming again. He's coming home. Hold on. Everybody hold on. No matter what they say, no matter what they do, no matter how it seems, God's got the final say. It doesn't matter how long it may seem, the end is what matters, but God's got the final say. So hold on, everybody, hold on, hold on, hold on, hold on, oh, hold on, hold on, forever, hold on. The enemies may hate, they can tell all lies. No matter how long, the truth will prevail. They can rise up against all the fans that stand up for him. The end will justify, for God has the final say. Oh, no, 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 yo. Hold on. Hold on. Hold on, hold on. Robert is coming home. It's coming back, so hold on. All fans, hold on. Hold on, hold on, hold on, hold on. Hold on, hold on, hold on, hold on. Help is on its way. Heaven is down here. Hold on, all fans, hold on. God is here, taking it over. Hold on, everybody, hold on, hold on, hold on, hold on.
I'm back. I am back. I need to share something with you guys. I got a phone call. Shout out to the person that I talked to earlier. Shout out to you guys. I need to share something with you. Who wants to play some parts for me? I want to do the Curcio hearing. Who wants to be Attorney Rodriguez? Who wants to be? Who wants to play with me? I need some readers. Can you play with me for a second? I need to show you something. I'm not gonna do the whole thing. Henny, are you in here? Are you in here? I need some players with me. I need someone to play with me. I have this transcript I want to read. You play? Okay, Tamiria. I'm gonna send it to you right now. Got Tamiria. Anybody else? Anybody else want to play with me? I just want to show you something. First, I'm going to play this thing with Ann Donnelly, Judge Ann Donnelly, and this is why I'm saying what I say. If you see my title, my title in this saying that Judge Donnelly is contemplating and digging in to make the right decision. Okay. She's not taking this lightly. She's taking it seriously. And I know everybody like, oh, Judge Ann Donnelly. You got to remember, she is not the one who declared Robert guilty. She was not. It was a jury. And I guarantee if it was her on the making that decision, that would have not went that way because she would have operated with the law. With the law. The law. Okay. I'm going to go ahead and play something for you. This is from the Brooklyn Center. They had an interview. They interviewed her. So I'm going to play this interview. I do not own the rights to this. This is for commentary. Where's the Fair Act use? I'm going to play that. I'm going to play this, and this is them questioning her on how she makes her decision, okay? That's why I'm telling you guys, okay, Fair Act. Copyright disclaimer. Under the Section 107 of the Copyright Act of 1976, allowance is made for fair use for the purpose of criticism, comment, news reporting, teaching, scholarship, and research, okay? What I'm going to do, I'm just bringing you guys information and I'm giving you my point of view on this, okay? You guys got to stop it with the negativity. Stop bashing the judge. Stop bashing y'all. Listen to law. Understand. The best way to get things done is to get understanding first, okay? I'm going to play this for you. Then I'm going to read the Curcio so you guys could actually hear what was happening, okay? How Judge Ann Donnelly was trying to be extremely fair to Robert, giving him a chance, helping him to understand what is happening and, those type of things. So you guys stop the bashing, stop doing all this extra stuff about the judge, okay? Got to stop, okay? Stop it. Stop it, okay? But I'm telling you that you need to be sitting down, praying, and asking God to reveal to Judge Ann Donnelly what the law is and what is happening to Robin, and ask God to be the just God and make the just to give Judge Ann Donnelly the mindset of his, so she can make the right decision. Okay, this is what we're going to do, but I'm going to give you guys some feedback here, okay? Some understanding, so you stop running around like chickens with your head cut off in your emotion. Stop with the emotion. Let's use logic. There's a time where we have to use the thing men use. Men use logic. Women, stop with the emotion, okay? Let's use logic. Let's think logically, okay? I'm going to go ahead and play this, and then we're going to go do the cursio, okay? So you can hear her concerns and her wanting to do the right thing by Robert. Robert made a decision, and so now you guys got to understand and stop with this extra stuff, making up stuff with this judge. Stop it. Okay, the judge's daughter does not work for Lifetime. Stop it. Stop with the nonsense. Get truth, okay? Just get truth, because she was in there trying to help Robert. Okay, I'm just going to tell you that right now. She told him, if Nicole had to choose between herself and you, she's going to choose herself. Are you sure you understand? Are you sure you want to keep her? She gave him chances and chances and chances. But because Nicole was in his ear, he chose to stick with her instead of taking the judge's advice. Okay? And remember, Judge Donnelly is not the one who made the decision of the verdict. It was done by the jury, okay? The tainted jury, okay? Robert, let's just face it, ineffective counsel, period. Let's just face it. That's what it was. Let's just be honest with each other. Let's be honest. Tell it like it is. All right, here we go. This is an interview done by Judge Ann Donnelly with the New York Brooklyn Center. All right.
Recent threats to judicial independence. Our presenters this afternoon are both fellows of the ACTL, and I am delighted to tell you who they are and turn it over to them. I'll be back after their presentation to introduce part two. Matthew Fishbein most
we don't want to
recently
hear.
served in the
We don't want to hear that. We don't want to hear that.
as
Hold on.
Executive Assistant District Attorney for the Investigations Division. As a litigator, you're muted, Matt.
Okay, here we go. He's asking Ann Donnelly questions.
Already getting off with a glitch, but thank you very much, Marcia, and thank you to the Brooklyn Public Library Center for Brooklyn History for hosting this event. And welcome to our audience, which I understand includes people from all parts of the country, not just Brooklyn. And that is particularly appropriate because our topic this afternoon is one of national concern, the threat to the independence of the judiciary.
Okay. Henny Hen told me to stop. She says that you guys are not hitting the like button. There's 95 of you guys in here and nobody's hitting the like button. So she asked me to stop and I have to listen to her. So when she's ready, when she's pleased with what you guys are doing, then I will continue. In the meantime, I'll play some music for you guys. Hold on. I listen to my people. They told me don't go, and I'm not going. Henny, they decide to leave instead of hitting the like button. They decide it's down to 78 now. It was 95. Got 47 likes. And we're going to be reading the Curcio as well. Both Curcio hearing. Come on, y'all, get them likes up. I'll put the information out and awareness of Robert. I gotta listen to my people, y'all. Sorry. Got to listen to my people. The people have spoken. Y'all making Henny mad, y'all. Y'all making Henny mad. Okay, they're making Henny mad. Henny gonna go off on y'all. Let's see. Hold on. Aw, hey, Tori. Tori, you in here? Tori, you in here? Hey, Tori. Good morning to you, Tori. All right, so I'm gonna play some music. So, kind of like that music mode. So when they're ready to for me to go, that's when I'll go. When they're ready, when they tell me when to go, I gotta listen to my folks now. Can't be hard-headed no more. Can't be hard-headed. Let's see. Let's play some music. Yeah, if y'all get 3 more, I'll 3 more. Yeah, they running off. They so mad. They don't even want to hit the like button. But you're in here. Come on now. The selfishness has got to stop. Got to stop. One more. Come on, one more. Can we get one more? Okay. Do we have that one more? Okay, thank you guys. Thank you for the likes. I appreciate y'all. Thank you for that. Okay, here we go. We're gonna go ahead and play this interview that Judge Ann Donnelly had, and they're gonna ask us some questions and regarding to the judiciary role and how she come about making decisions and things like that. As you guys know, those who are not familiar with what's happening, Judge Ann Donnelly received two motions from Robert's attorney, Jennifer Bongine, 29 and a 33. One is for acquittal and one is for a new trial. And she brought up some things that are alarming and that the judge is taking very serious consideration for these things, and she's not taking it lightly. And folks are saying, oh, she's just holding up. No. Judge Ann Donnelly, she's going to explain to you in her own words how she go about making a decision. Guys, if you got to remember when Trump was trying to keep the people from she's the one who put the halt for him deporting those people. Remember, she was that judge. It was her that did that. Okay, she doesn't go by the beat of the drum of the people. She goes by what the law is, and she sticks by the law. And I'm going to give you some of my personal what I personally viewed, what I experienced at the courtroom, in her courtroom. Okay, I felt that she was not a Judge Ray, because Judge Ray was not having it. Okay, I'm just gonna tell you, Judge Ray was not having it, but it was a different type of case as well. This was a criminal case with Robert, and Judge Ray's case was a civil case. But Judge Ray made sure he took care of everything so things wouldn't have to go to the appellate court, right? So that's the difference between her and Judge Ray. Judge Donnelly, because the incompetency of the two attorneys that was there for the longest, she really went towards the government side. And here's because I'm gonna tell you, she was chastising the government left and right. I'm just gonna be blunt with you. She was chastising them. Okay, even when different laws and things like that came about, it was Calvin that was doing more of the researching and things like that. I didn't see the others doing that. Okay, I'm just gonna tell you. Okay. Even when at the end, when judge asked for certain things to be submitted, some stipulation stuff, Calvin and Canick was the one doing the legwork. Tom and Nicole was not. I'm telling you as an eyewitness of what I saw. Okay, can't tell you what anybody else did. They left. Canick and Calvin stayed back. They were in that law library getting cases and things like that to submit because there was a deadline. I personally saw that. Sylvia, saw that with my own eyes. And those who were in the courtroom saw it as well. They may not mention it, but I'm going to tell you what I saw, okay? It's not being biased. It's not picking on anybody. I'm just telling you facts, okay? All right, here we go.
What I'd like to do is to start with an example of this threat. In February of 2019, the Alaska Supreme Court issued a decision holding that a state statute which narrowed a woman's eligibility to receive Medicare funding for abortion was unconstitutional. The court found that it violated the Equal Protection Clause of the state constitution because it imposed more onerous Medicare eligibility requirements on women who were seeking abortion than women who sought to carry a pregnancy to term. As you might imagine, this would...
Jamel 7 Israel says, how many times will our people be deceived? If she was about his freedom, especially concerning his other case, she would delay his sentences until after the next case, but choose not to. I guess you didn't listen to Patrick, when he was on my live, you probably need to go educate yourself on that one. Probably because I was thinking the same thing until he explained some stuff to me. I think you probably need to go ahead and look at that. Probably need to go check what Patrick said on that one. I'm not a lawyer, but you probably need to go check what he said on that one. So, and you don't have to listen to this. You don't have to listen now. It's your choice. You don't have to be here. Don't come in here bashing what I'm bringing out, because you can just step. I'm bringing information. I'm not telling you to believe anything. Just giving you information and personal experience. All right, here we go.
A controversial decision. It was hailed by some and reviled by others. One of the people who hated the decision was the governor of Alaska. But as governor, he did not have the power to undo the court's decision. Governors cannot reverse decisions of the judicial branch. But instead, he found a way to retaliate against the court. Several months later, in June of 2019, the governor vetoed salary increases for Alaska appellate judges, including the judges on the Supreme Court, which had previously been passed by the state legislature. And he also issued a veto which had the effect of reducing the appellate court's budget by $300,000. Now, the governor made crystal clear that these vetoes were explicitly tied to the court's decision. He explained, and I'm quoting, "The legislative and executive branches are opposed to state-funded elective abortions. The only branch of government that insists on state-funded elective abortions is the Supreme Court." And so, he explained, he was reducing the court's budget by the annual cost of elective abortions. Now, regardless of whether one believes that the Alaska court's decision was correctly decided, the Alaska governor's actions raised severe concerns because they challenged the very underpinnings of our constitutional government, that the courts are the final arbiters of the law, final arbiters of what the Constitution means, and should be insulated from political considerations and retribution. Regrettably, as you'll soon see, the Alaska veto did not stand alone. It's just one example of a growing trend in many states across the country that challenge the independence of the courts and their role in our system of government.
Our program today is going to focus on the importance of fair and impartial courts to the rule of law. And we're going to examine some of the recent challenges to maintain that status. That's going to happen in the second portion. As Marcia said, Matt and I are going to present a short refresher that the American College of Trial Lawyers and the National Association of Women Judges put together on the role that the courts play in our constitutional system and how that role is different from the roles of the other branches of government. It's a nonpartisan refresher that is intended to be a good lead-in to the panel discussion that's going to follow. So I mentioned the rule of law. John Adams defined a republic as a government of laws, not men. Today, we would say a government of laws, not people. And what that means in simple terms is that no one is above the law, regardless of that person's position in the government or society, or regardless of how powerful that person might be. That includes members of Congress, the president, and judges. It also means that the government itself must obey the law. Congress cannot pass legislation that exceeds its power under the Constitution. The president and members of the executive branch cannot take actions that exceed the powers that are given to them. So the principal role of the courts in our system is to follow and enforce the rule of law, regardless of any political consequences.
So Judge Donnelly and I are going to focus on 4 topics. The first is we will examine the unique role of the judicial branch in our constitutional design. We'll distinguish between what judges do and what other government officials do. We'll evaluate the significance of the judicial branch and the need for fair and impartial courts. And then we will explore some of the recent challenges that are facing the courts. Next slide, please. What does the, hold on, I think yeah. So let's start with the branches of government. As we probably all learned in civics classes back in high school or middle school, there are 3 branches of government in both the federal system and also in each of the 50 states. There's the legislative branch, which in the federal system is Congress, and in the states, the state legislature. They're responsible for enacting the laws. Then there's the executive branch, the president or the governor if it's a state, which is tasked with executing the laws, enforcing the laws through cabinet agencies and administrative agencies. And finally, the judicial branch consisting of trial courts and appellate courts, whose job is to adjudicate the law in cases that come before the courts. So let's first look at what the judicial branch does. Judge Donnelly, as Marcia said during the introduction, you were in somewhat of a unique position, having served both as a state court judge and now as a federal judge. Why don't you start by telling us what exactly do judges do?
Well, in really simple terms, judges resolve disputes between parties, whether that's on the civil side or on the criminal side. Obviously, a court can only act when a case is brought before the court. A judge can't reach out on her own and decide that she's going to interpret a law or rule on its constitutionality. So when a case does come before the court, the role of the judge is to apply the law to the facts of the case and then explain how it is that the law does apply to those facts. Sometimes that case is going to involve reviewing a law that the legislature has enacted to determine whether the law is constitutional. Sometimes it might review an executive branch action to determine whether the governor or the president has exceeded her powers under the Constitution. But most cases, it simply means applying the law to the facts and circumstances of everyday disputes that come before the court, either, as I said, as a civil lawsuit or a criminal matter.
So, Judge, talk a little bit about how judges make decisions.
Well, judges make decisions based on the law and on the facts of the case. A judge has to be fair and impartial and interpret the law regardless of any personal opinion the judge may have. And the judge has to apply the law as it exists to the facts in the case before the judge. And in addition to not being influenced by any personal feelings, the judge can't be influenced by any views of other people or by political consequences of a decision.
So what does it mean to follow the law? How does a judge determine what the law is that applies to a particular set of facts and circumstances?
Well, depending on the case, the judge is going to use different sources to determine what the law is. We don't start with a blank slate. So we'll look to the Constitution, the U.S. Constitution or the state constitution. We'll look to statutes that have been enacted by the legislature and also to prior judicial decisions. All judges, at least in the district court and in the mid-level courts, are bound by what's called stare decisis, which means that we must follow decisions of superior courts that have been decided in similar cases. So as a district judge, I'm obligated to follow the Second Circuit, Court of Appeals, and the Supreme Court of the United States. Sometimes there's no guidance from the Second Circuit, and a judge may look to decisions in other circuits to make a decision.
Are you hearing what she just said? Should I repeat that? Should I repeat that? Should I repeat that part? Did you guys get a full understanding what she said and how she's making the decision in regards to this Rule 29 and then Rule 33? She has received this since March 21st. It's been a month and I would say a couple of weeks, right? And no decision has not been made yet. Do you want to? Oh, you said repeat it? Okay. All right. I'll repeat it right here. I'm sorry. I'm going to try to get it the right spot. Hold on. All right. Hopefully I got the right spot. Hold on.
It's constitutionality.
Hold on.
So when a case does
States. There's the legislative branch, which in the federal system is Congress, and in the states, the state legislature.
Hold on.
They're responsible for enacting the laws.
All right. Hold on.
Why don't you start by telling us what exactly do judges do?
Well, in really simple terms, judges resolve disputes between parties, whether that's on the civil side or on the criminal side. Obviously, a court can only act when a case is brought before the court. A judge can't reach out on her own and decide that she's going to interpret a law or rule.
Did you hear this? A judge cannot reach out on her own. Meaning all those who saying, oh, she's holding it back because she's going to just rule against him, whatever. No, she has to go by what the law is. She's being very meticulous at this. This is not a joke. This is the man's life here, okay? The jurors made the decision, okay? Jennifer Bongine has brought some valid laws and valid things that she has to contemplate. She has to dig deep in what the law says. What the law says, not what she feels and what the prosecutor said. No, what the law is, okay? That is why it's taken so long. It's not about what she has to follow the law, because if she doesn't, the appeals court is going to go ahead and do that anyway. So what she's doing is finding out what has the appeal court, what are they going to say about this particular thing. So all those naysayers and haters and oppositions and all those people who's bound to saying that this is going to happen to Robert, just watch God, okay? Just watch God.
On its constitutionality. So when a case does come before the court, the role of the judge is to apply the law to the facts of the case and then explain how it is that the law does apply to those facts. Sometimes that case is going to involve reviewing a law that the legislature has enacted to determine whether the law is constitutional. Sometimes it might review an executive branch action to determine whether the governor or the president has exceeded her powers under the Constitution. But most cases, it simply means applying the law to the facts and circumstances of everyday disputes that come before the court, either, as I said, as a civil lawsuit.
Thank you, Jocelyn. That's right. Keep Rob's name out of your mouth if it's not positive. Amen on that one. Okay, sorry. I had to pause a minute and just like breathe, like keep his all naysayers, y'all, they up in here. Block. This is not the time for it. This is education time. You don't speak in class when the teacher's teaching, okay? Time to listen.
Or criminal matter.
So, Judge, talk a little bit about how judges make decisions.
Well, judges make decisions based on the law and on the facts of the case. A judge has to be fair and impartial and interpret the law regardless of any personal opinion the judge may have. And the judge has to apply the law as it exists to the facts in the case before the judge. And in addition to not being influenced by any personal feelings, a judge can't be influenced by any views of other people or by political consequences of a decision.
So what does it mean to follow the law? How does a judge determine what the law is that applies to a particular set of facts and circumstances?
Well, depending on the case, the judge is going to use different sources to determine what the law is. We don't start with a blank slate. So we'll look to the Constitution, the U.S. Constitution or the state constitution. We'll look to statutes that have been enacted by the legislature and also to prior judicial decisions. All judges, at least in the district court and in the mid-level courts, are bound by what's called stare decisis, which means that we must follow decisions of superior courts that have been decided in similar cases. So as a district judge, I'm obligated to follow the Second Circuit, Court of Appeals, and the Supreme Court of the United States. Sometimes there's no guidance from the Second Circuit, and a judge may look to decisions in other circuits to make a decision.
Thank you. You referred to the fact that sources of law could include state statutes, federal statutes, the Constitution. In determining the governing law, judges must sometimes analyze competing sources of law, sometimes which are in conflict. As you can see from this chart, there's sort of a level of law. The federal law and the U.S. Constitution take priority over state law. And this is because of the supremacy clause in the U.S. Constitution, which says that federal law is supreme. The U.S. Constitution, of course, is the highest authority, and that takes precedence over federal statutes, state statutes, and decisions from lower courts.
So in our federal system of government, we have both a federal court system and a state court system. Each one of the states has its own state court system. And it sometimes seems like federal courts get a lot of the attention, but the fact is that about 90% of all cases are heard in state courts.
Thank you. So you've probably touched on this somewhat in your prior explanations, but how is the judicial branch different from the other branches of government?
Well, aside from the different functions that you discussed earlier, the principal difference is that the judiciary is not a political entity. The legislative and executive branches are political entities, and courts are meant to be insulated from politics. And that's true even if judges are elected to their positions.
So the legislative and the executive branches are, of course, not insulated from politics. They're designed to be responsive to the will of the people. And as a result, it's to be expected and perfectly appropriate for legislators, governors, the president to listen to and be responsive to public opinion, to lobbyists, to all sorts of political pressures.
The judicial branch, as I said before, was designed not to be a political or representative branch. So a judge can't be influenced by public opinion, by political.
Dennis, why don't you try seeing that the glass is half full instead of half empty? Why don't you pray about it and ask God to help change some of this? Because the negativity is not going to work. It's not going to change Robert's circumstance.
Political pressure or by special interests. As I explained before, the judge is duty bound to follow what the law is, regardless of any of those outside pressures. When a judge acts in accordance with her constitutionally assigned role to interpret and apply the law, the court honors the fundamental democratic principles that laws are to be enacted by the representatives of the people, and that the separation of powers has to be maintained by the branches of government. Now, there are times and in our history when the law is expanded. And I think one of the, and so law. And I think one of the most recent things.
Okay, I'm going to read an article that just went out today. The subject is the public article, just to reiterate that no longer playing with judges. The Federal Appeal Court on Tuesday revived a former public defender's lawsuit challenging that federal judicial handling of her sexual harassment and discrimination claims about supervisor unwelcome attention at work. The three-judge panel sided in part with Carolyn D. Strickland, a former public defender in Charlotte, and said U.S. court leaders are not entirely shielded from being sued by a judicial employee. On the Fourth U.S. Circuit Court of Appeal partially reversed a judge dismissal of a 2020 lawsuit by Karen Strickland, who alleged she was sexually harassed by a supervisor and stonewalled in her efforts to have the Judiciary address her complaint. In this article that I told you all yesterday about in the back room. Oh, sorry. My bad. It was the Fourth Circuit Court of Appeal that actually revised the case. They revised it, which means they are also looking over previous cases they reviewed and re-reviewing them. Okay, sorry guys, that was for me. Right. Okay, but cases are being scrutinized right now by judges. And I just wanted to give you sorry, that was my message. That part was for me. All right, here we go. Dennis, how do you know she's lying? How do you know she's lying? You know her? How do you know she's lying? Please refrain from putting negativity. Please refrain from putting negativity in the chat. I'm warning you, Dennis Jones. You put negativity one more time, you will be blocked. Please keep that kind of opinion to yourself. Like, we're trying to keep this in a positive keel here. I just don't want the negativity in here. I don't. You don't know the lady to know whether or not she's lying, okay? Let's not put stuff out there that is not truth, okay? Do you know her personally? Has she lied to you? So please, let's stop the negativity. Whatever feelings you have, keep it to yourself. We're trying to keep this thing. This is informational purposes only, okay? Like if you're in the classroom, you don't yell out to the teacher, oh, you're wrong. No, that's not what you do. You listen to what the teacher say. You take in what you need to take in and throw out what you need to take out. Don't throw negativity in the chat. Please, let's not do that. This is information. If you don't like what's being said, you don't just bow out gracefully. Let's not taint what's in here, okay? Let's not do that. Let's not taint it, okay? One bad apple, we don't want to spoil a whole bunch. This is not what it's for. This is not a bashing. Let's bash Judge Donnelly. No, that's not what it's for. It's for you to listen, comprehend, take in, get some information. That's what it's for. All this negativity, wrong place, okay? Wrong place. It's not for it here, okay? All this extra stuff, y'all. Come on, let's stop it. Whatever aggression that you have, go in a boxing field. Go box. Let's not do it in here. Okay, let's not do that. Okay, that's not what it's for. All that ugliness. It's not necessary. Sitting here calling a lady a lie. You don't even know what the lady is. You never talked to her. You don't know her. You don't know who she is. Stop it, okay? Stop.
Examples of that, although they exist all throughout our history, are the marriage equality cases. And those are a good example of a time where the laws have changed.
Okay, next slide, please. In following the law, judges often make difficult decisions that may not be popular. This applies not only in cases of constitutional dimension, but in many day-to-day decisions.
You know what I need you people to do? Instead of complaining, take some action. Start campaigning and start getting in a position so you can make some changes in the law. Why don't you do that? Instead of being the problem, part of the problem, be a solution. Don't sit around just spewing negativity. Do something that's going to make some changes in the law. The law is given by people who make the law. You know what I'm saying? We part of it, and when we don't vote, you're saying it's okay to have that type of law. When you don't run for a position and become that candidate, you're saying it's okay to do this law. Get what I'm saying? Stop complaining. Be a solution. Get out there and make some changes, okay? That's what you do. Stop. Oh, this person this and this person. Stop it. Stop. Be the change. Exactly, Joyce. Be the change you want to see. Stop complaining. Complaining ain't going to help. The only thing is going to get a whole bunch of people sitting in the corner murmuring and complaining and making life miserable for everybody else. Get out there. You see a problem. You see a situation you want to change. Get some petition going. Change some law. Do some marching. Do something. Instead of sitting there trying to be a bunch of, stop. This is not the place for it here, okay? You're not going to be part of the solution. Stop it with the complaining and murmuring. You're going to make yourself sick. Stop it. Stop it. Stop it right now. Stop it. It's about learning, making changes, okay? That's what it's all about.
Here's an example. Think of a lawsuit challenging the
Go to law school. Become a lawyer. Become a judge. That's what you do. Oh, here we go.
Construction of a housing.
Flip Flame, you coming in here with this nonsense too. Y'all, all this negativity, people don't want to do right. Block them. Block. I'm tired of this. Ugh. All this negativity. Ugh. Stop it. So what? Who cares? A lot of people don't like people. Stop it. You don't like me. Why? Stop.
In an environmentally protected area. Let's say.
Hold on. Hey, Gotti. Y'all, look who's in here. Hey, Gotti. Gotti has showed itself. Okay. Oh my God, yo. Oh. I like when we do prayer. I like when we do affirmation because we don't get all this negative stuff in our affirmation. Maybe we should start doing our affirmation right now. Because, yes, perspective, like, oh my, OMG, yes. It's like all the negative folks come out. Why y'all? Ooh. Hey, Gotti. Thank you. But God. Amen, Joycelyn. But God. It's like, I just want to scream. All right, let me go ahead and finish playing this and then do the Curcio hearing because Yes, he is. That's the thing. They don't have belief in God. They don't trust God enough. They don't pray enough. Mm, mm, mm.
One which is populated by migrating birds. In deciding whether or not the law prohibits or permits the construction of the housing, the judge cannot consider such factors as whether there's a pressing need for housing. The judge can't consider if he or she has a personal interest in the environment or in migrating birds. The judge should not consider that there's a 90% approval rating of the housing project or an opposition to the housing project.
The unique role of the judiciary is best illustrated in the protection of minority rights. The Constitution and other laws recognize that certain rights take precedence even in the face of majority rule. For example, the First Amendment freedoms of speech, religion, press, and assembly are examples of that. So even if 99% of the population were to oppose the right of white supremacists to demonstrate peacefully in Prospect Park, courts have the responsibility to protect the First Amendment rights of those groups to do so, regardless of their popularity. The courts serve as a bulwark that protects the rights of minorities, even in the face of overwhelming popular opposition.
Now, as we have seen, that's the ideal. The ideal is that judges should be insulated from politics. But what is the reality? Is it even possible for them to be such insulated? We've all seen the emphasis in recent years by both political parties on the selection of judges and the focus on certain hot-button issues and how those judges are likely to decide them. Issues such as reproductive rights, voting rights, religious freedom, among many others. Those issues and how prospective judges are likely to rule on them certainly seem to be on the minds of the senators who are charged with voting on their nominations. Now, prospective judges are not permitted by ethical rules to prejudge matters, and we've all seen congressional hearings where senators are extremely frustrated because they can't get the nominee to give a definitive answer on how they would rule on a particular hot-button issue. But that being said, it would be naive to suppose that politics do not enter the decision of who gets nominated and confirmed. What about after the judge is on the bench? Judge Donnelly is someone who has served on both the state and federal bench. How often, if at all, do politics or public opinion enter into your decision-making or the decision-making of your colleagues?
Well, the fact is that 99% of the cases that come before most judges, and that's certainly true in the district court, have no political dimension at all, and no public interest beyond the parties that appear before the judge. But in the few cases that might have a broader interest or involve controversial issues, which does happen from time to time, my experience is that judges do their level best to keep those factors out of their decision making. And I can only point to my own court as an example of the Eastern District of New York. In our court, we have judges that were appointed by every president imaginable, going back. And it has been my experience on that court that every judge, to a person who appointed him or her, is studious and follows his or her duty to apply the law to the facts of the case, regardless of what the political consequences are.
Now, federal judges, as you are today, are nominated by the president and have life tenure after they're confirmed by the Senate. And the only way they can be removed is by impeachment for high crimes and misdemeanors, which I think has happened just a handful of times in the history of the country. The argument for life tenure is that it helps insulate judges from public pressure and political influence once they sit on the bench. And we've all seen instances where Supreme Court justices have voted in ways that surprise people, that seem contrary to what everyone presupposed were their political leanings. But let's talk a moment about state courts, where you've said that 90% of all cases are heard. How are state court judges selected, and what type of tenure do they tend to have?
So across the country, I mean, there are the state court methods of judicial selection really run the gamut, from partisan elections where the candidates are supported by political parties. There are also nonpartisan elections, gubernatorial appointments, legislative appointments, and then there are some hybrid methods. But unlike the federal judiciary, in the state court, there is no life tenure except for the 5 judges who sit on the Rhode Island Supreme Court. So the Brennan Center has prepared a slide that shows all of the ways that the highest courts in the different states are selected. And you can see by the different colors that, as I said, these selection processes they run the gamut. There are nonpartisan elections, there are merit selection, gubernatorial appointments, and various hybrids. In New York, judges reach the bench at various levels through different ways. Some are appointed by either the governor or, in the case of certain lower courts, by the mayor. There are partisan elections for judges. And in the case of the New York Court of Appeals, which is our highest court, there's a hybrid system where a nonpartisan committee submits up to 7 names to the governor, who then has to choose someone to nominate, and then that person has to be confirmed by the state Senate.
So even where judges are elected and endorsed by political parties, the ideal is that they are different from candidates running for legislative or executive offices. For instance, as I think I mentioned earlier, they're prohibited by ethical rules from saying how they will decide on various issues once they ascend the bench. So they can't campaign promising to rule a certain way on a certain issue. This statement from Chief Justice Roberts reflects how it's supposed to be. Chief Justice said, "Judges are not politicians, even when they come to the bench by way of the ballot. And a state's decision to elect its judiciary does not compel it to treat judicial candidates like campaigners for public office. The state may assure its people that judges will apply the law without fear or favor." Now, as I said, that's the ideal, and I expect one of the topics that the panel is going to cover following our presentation here is whether, in fact, it works out that way. Go to the next slide. In addition to concerns regarding the politicalization of the judicial selection process, another threat to the independence of courts in recent years has come from state legislatures. Take a look at this map, another graphic prepared by the Brennan Center. The yellow color indicates states that have attempted to limit the court's role or independence in one way or another. These attempts include interjecting greater politics into the selection process. One recent example is the state of Indiana, which presently has a nonpartisan selection process. There's a legislative initiative now to change that in favor of partisan elections where the judicial candidates would be supported by a political party. Some legislatures have taken actions to try to remove judges in response to unpopular decisions, such as having recall procedures. There have been efforts to punitively reduce judicial compensation, as we saw in the Alaska example. There have been initiatives to shorten judicial terms. And there have also been some states who have attempted to enact laws to prohibit state and official state and local officials from enforcing federal court orders. One example of that is Judge Donnelly mentioned the recent Supreme Court marriage equality issue. Some state legislatures proposed legislation which would have prohibited state officials from registering same-sex couples who were looking to get married. We'll hear more about these developments from our friends at the Brennan Center in a few minutes.
The trends that Matt mentioned have raised concerns from people regardless of their political persuasion. Retired Justice Sandra Day O'Connor had this to say about it. I am anxious about the state of the judiciary in America. What worries me is the manner in which politically motivated interest groups are attempting to interfere with justice.
Those words from Justice O'Connor conclude our part of the program. In the panel that's following, you'll hear a discussion in greater detail of some of the more troubling threats to the rule of law and the efforts to confront them. So on behalf of Judge Donnelly and the American College of Trial Lawyers and the National Association of Women Judges, we hope that this refresher has served to set the stage for that discussion. Thank you.
All right, hold on a second.
And that was fascinating and interesting and full of great information. Now we pivot to a conversation that centers this civics lesson in the here and now, with four eminent panelists, all working on the ground as activists and advocates for fair and impartial courts. And I am truly, truly grateful to the Brennan Center for Justice, and in particular their Democracy Program and Fair Courts Project, for bringing these panelists together. As they engage in conversation, I also want to invite all of you listening to join by typing your questions in the Q&A. And now I will briefly introduce our panel, and it's going to be brief. And I could speak at length about all of these folks because they're all incredibly distinguished. But in the interest of getting to it, forgive me for abbreviating. Patrick Berry, we'll start with, is a fellow and counsel in the Brennan Center's Democracy Program, where he focuses on voting rights restoration and promoting fair, diverse, and impartial courts. He received his BA from the University of Central Florida and his JD from the University of Pennsylvania Law School, where he was an executive editor for the Journal of Law and Public Affairs. Welcome. Catherine Personnette is Deputy Director of Campaigns at the Pennsylvania Budget and Policy Center. Recently, she has been in the eye of the storm, fighting on the ground to keep PA's courts fair through a constitutional amendment and other activities to prevent judicial gerrymandering, which you will hear more about. Welcome, Kat. Welcome, Katie. Eric Lesh is Executive Director of the LGBT Bar Association and Foundation of Greater New York. And Eric previously served as Lambda Legal's Fair Courts Project Director, where he focused on eliminating bias in the legal system, increasing diversity of the judicial bench, and expanding access to justice for LGBT people and those with HIV. He is widely published, including a 2017 publication titled Justice Out of Balance: How Judicial Elections and a Stunning Lack of Diversity on State Courts Threatens LGBT Rights, which was featured by Adam Liptak in the New York Times. And last, but by no means least, is Alicia Bannon.
Hold on a second, y'all.
Alicia
Okay.
getting to bring it home.
Sorry about that. I had to
a
push it
practice
forward
Lexis.
to
I
another
felt like
one.
I
Sorry.
had, a very interesting set of opportunities in the law here in Texas, and I got to live here, and so I share that path with Justice Palmer. In terms of transitioning, or what I learned being a still a relatively young judge, I've only been here now about 3.5 years. I'd always understood in theory as a litigator, both in private practice and in government, that judges are generally hardworking, they're devoted to their craft, but they're just very, very busy people. There are a lot of cases on their docket, and when you're in practice, whether in government or private, you've got whatever handful of cases you're handling. But whatever you're doing, however busy you might think, it just pales in comparison in terms of the numerosity of cases on your docket, and so you should be prepared to litigate that way. There's just no world in which your judge, no matter how devoted they are to their job, and judges, my experience has been judges are by and large very devoted, very hardworking, and doesn't matter how interesting your case is, they're not going to be able to spend anywhere near the amount of time getting ready and learning every nook and cranny of the case law or the record as you do. And so in a way, the job of a litigator, of an advocate, is part teacher as well as part advocate. And of course, being a teacher, you have to be a credible teacher, knowing how to present your case to a panel or to an individual judge in a way that seems and is fair, while at the same time understanding that you're obviously engineering for an outcome that is favorable to your client, and striking that balance. Anyway, I say all that to say that becoming a judge has reinforced that principle in about the most intense way possible. If I was asked, what's my biggest frustration being a judge, it's honestly the inability to spend anywhere near as much time on each case as I used to be in any number of my previous positions. And frankly, even being a law clerk really doesn't give you a full picture. It gives you a good picture, to be clear. But on our court, you get 4 law clerks, and so each clerk only sees at most, at least in a sort of robust way, 1/4 of the docket. And to be clear, it's actually much less than 1/4, because there's a lot of stuff that judges do that we never even give to the clerks. And so a law clerk, you get a picture of what it's like to manage multiple cases, and not just to be learning about them, but actually be casting a vote and putting your name to a position. But even as a law clerk, like I said, you're really just seeing one slice of it. I should know. I actually have met to look at the statistics, trying to figure out how many cases we have to decide in how much period of time. But my bet is it would be shocking to most people. And I can only imagine on intermediate state appellate courts and state trial courts that the numbers are much worse. They really just have to, just get through, and you're almost like a conveyor belt. And that's something for every advocate, no matter what position you hold in the legal system, to always take account of.
Great, thank you. Judge Donnelly.
Well, I guess I'm in the sausage factory aspect of the judicial system as a trial judge. First of all, I'm so happy to be included in today's event. Such an interesting topic. I always learn something from doing moot courts like this. So I'm from the Midwest, and I went to New York, and I never came back. So I've been in New York now for more than 35 years, almost 40 years. And I was a prosecutor for about 25 years as an appellate lawyer starting out, and then as a trial lawyer for a good portion of that. I don't remember what all the questions were, but I'm going to try to do my best. I'd say I think one of the questions was, what's the transition from being an advocate to being a judge? And I would say that the most important quality, which would probably serve you well as a lawyer too, is just being able to listen and obviously be a good lawyer. But I find that I talk a lot less as a judge than I did as a trial lawyer. And that's because as Judge Ho said, I rely on lawyers to, give me the foundation for the case, whether it's factual foundation or a legal foundation. And then we do have just what could be characterized as a crushing caseload, I would say. Having been in state court, sometimes those caseloads are even worse. But we have a full complement of civil and criminal cases. And just one other thing that I've learned is that every case is important to someone. There's no case that is unimportant. And I recall that as a state court judge, if I would handle misdemeanor cases, sometimes people think they're not such important cases, but they are. And so I try to keep that in mind, that for litigants and for lawyers, these cases are all very important. And then the other thing that I try to keep in mind is that having been a courtroom lawyer for such a long time, I have vivid recollections of being yelled at by judges. I think that happened more in the 80s and the 90s than it does now. I'm not positive. But I do remember that it didn't feel very good to be yelled at or embarrassed in court. And so I do try to remember what it's like to be a litigant and how much work you have to do to prepare for your cases. So I hope I'm not mean to anybody, but just trying to remember how it felt to be an advocate.
That's great. Thank you. I want to pick up on the very last thing you said, Judge Donnelly, and ask a question that's maybe of particular relevance to the 4 students who will be arguing later today, which is, what are the things that advocates do in front of you that you think are particularly effective or particularly ineffective? What makes for an especially good or bad advocate in your court? Judge Donnelly, do you want to start us off?
Sure. Well, one thing that I always tell people is that there are 1,000 roads to God. There are 1,000 roads to be, 1,000 ways to be a good lawyer. So it's not always being the most flashy person in the room, but the critical tools that you can bring to your job as an advocate are preparation for your case, which always shows, and being straightforward with the judge or with the jury about what the record is, and making your case persuasively. I've sat on the Second Circuit a few times as a visiting judge, and I'm always most impressed by people that speak plainly, but have a thorough knowledge of the record. One other thing that I don't find particularly helpful, I really don't like it when lawyers, I don't know if fight is the right word, but sometimes people feel very passionate about their position, and sometimes they don't treat each other very well. I find that not helpful. In written submissions, when things are underlined or in all caps, or somebody using the word outrageous. So I sometimes think you have to just remember that the judge doesn't always want to hear that. But I would say the number one thing is being prepared, just knowing the record of your case, knowing the case law is the most important quality that you can bring to an effective argument or trial.
Thank you. Justice Palmer.
No, I agree with all that. I think that in an appellate court, there are differences between arguing in a trial court and an appellate court, and between arguing in an intermediate appellate court and the U.S. Supreme Court or a state Supreme Court. When you're in a trial court, you're saying, look, this case is like this case just decided by the New York Court of Appeals or just decided by the Second Circuit. And so it's within this line of cases, not that line. When you're before, and similarly in an intermediate court of appeals, this is what, like this line of Supreme Court cases, and here's why. When you're in a court of last resort, we're trying to figure out what should the rule be. And you're not going to get away by saying, oh, this is like your other cases, but not at all like these cases that your court decided. If it was like that, we wouldn't have taken the case, wouldn't have allowed review. We took it because it's going to give us an opportunity to articulate an important rule for the lower appellate court and the trial courts. So think about, particularly if you're in an appellate court or a court of last resort and a court of last resort in particular, what's the limiting principle? What's the rule of law you really want to come out of this case? It's not just as you are in trial court, just trying to get the ruling in your favor. Think about that. Certainly no ad hominem attacks, no statements about what an idiot the trial court was or how awful the opposing counsel is. No jury issues. Don't tell me how bad the injury was. That we're here in an appellate court because there's a legal question, and I want you to help me, for you and your client, figure out what the correct answer to this legal question is. It's a discussion.
Okay, terrific. Thank you very much. Judge Ho.
So I want to pick up on a theme that I think Judge Donnelly opened with, which is that seeing lawyers bicker and what Justice Palmer said about insults towards anybody is one of the worst things you see as a judge. Hopefully you don't see many insults in the courtroom, but you do see quite a bit of fighting and bickering. And I think it sort of misunderstands how the litigation process is supposed to work, even though it's actually quite common for lawyers. And it certainly misunderstands the appellate process. And I think of the appellate process in particular, but I would think lawyering generally, as one that you should view primarily as an intellectual exercise, at least in front of the judge. I'm not a jury. I've never done a jury trial or anything like that, so I'll let others speak to how to handle juries. But certainly from a judge's perspective, it's an intellectual process. And so I think advocates are better off when they view it as an intellectual process as well. And towards that end, being intellectually honest. Everybody understands that you're there wanting a certain result. Nobody will be confused by that. Given that, making sure that you are always candid, making sure that you maintain your credibility at all times. We understand that you're pushing for a particular position, but if you ever overstate something, whether it's saying that a case says X when it doesn't quite say X, saying that the record proves Y when in fact it doesn't, those are not good moments. And those are moments that I certainly remember when a lawyer has told me something, and either in that moment or later on, I find out that turns out to be not true. It's not just that you've lost credibility on that moment; it's that you've really lost credibility across the board. One of my dear friends is actually one of the advocates in that case that we're going to be mooting today. Mark Perry at Gibson Dunn used to tell us, as rising appellate associates, if we can't trust you to get the commas right, we can't trust you to get the law right. And I always took that very much to heart, that both as an associate, just doing a good job site checking and whatnot, but also as an advocate, talking to judges, never, ever, ever destroy your credibility, because you can build a lifetime of good work and reputation and destroy it in a moment by overstating. And then the last thing I would say, absolutely, it's all about preparation. One specific aspect I'll note is, particularly when you're at the appellate phase, understanding that there's multiple ways to look at a case. So I always would tell, when I had to moot a case in practice, I would always have a moment, halfway or so through the process, I would ask everybody, okay, if we could change sides right now, obviously you're not allowed to do that, but if you could, hypothetically, would you do it? Would you want to switch sides, and why? That inevitably created interesting dialogue and allowed us to probe our case in yet another way. So certainly trying to understand exactly why the other side has good points, and really trying to appreciate why their position's not as crazy as you might want people to think, and really get in under the hood on that. But also not just switching sides, but also understanding that your judges, who are not obviously on any side, they're just trying to decide what the law is, that judges have different views. So understanding originalism, understanding textualism, understanding the role of precedent, understanding that people do care. Even the most hardcore originalists at least wonder what the practical consequences. And so being able to understand a case and all the various aspects of it through every possible lens. If you're relying heavily on precedent, that's great. But you better have a reason why the precedent is correct or fair or good for the society, or at least good textualism or good originalism. Having all those things nailed down in every possible way. That way, hopefully, if you're prepared enough, there's no question that you will not expect.
Great, thank you very much. I guess I'd like to ask now about sort of parts of your docket, the types of cases that arise in front of you. And I'm curious whether there are particular parts of the docket, maybe particular subject matter areas of cases or types of cases that you find particularly difficult or challenging in some regard, or parts of the docket, maybe it's the same, that you find especially interesting or especially rewarding in some regard. Certain types of cases that you have particularly strong feelings towards, given the different types of dockets that I assume your courts experience. So Judge Ho, maybe you could start us off with this one, please.
Sure, that's a great question. One of the both benefits and detriments of being a generalist judge, just like I was actually a generalist appellate lawyer previously, is that you get to try something new every day and learn new areas. With that said, there are some areas of the law that are relatively straightforward, and others much less so. And in particular, what I'm going to focus on is those areas of the law that really actually don't really feel like law. To give you one recent example for me is I forget the name of the statute, but it's the IDEA, Individuals with Disabilities Education Rights. Those types of disputes typically involve having to get very detailed into scientific disputes and disputes about educational pedagogy, specifically in the context of the mentally disabled. We're judges, and Congress has called upon judges to decide those disputes, and of course we try to rise to the challenge. But I got to tell you, that's not an area of experience for me, and so I get really nervous trying to figure out which expert to believe, and I worry that I'm really kind of outside my depth. You give me a statute, I can, I'm 20 years on the law, I can, figure it out, or at least I can figure out why it's hard. And so, those areas I get, but anytime when you have a dispute that really rests on battles of the experts, I gotta tell you that I start to worry that I'm outside my depth. Perhaps that's the benefit of being an appellate judge. I think Justice Palmer may have alluded to this, is, we basically get to defer to the district court. And so as long as it's a close enough question, then we just kind of bless whatever happened below. But that, of course, leaves it to district courts to have to make those calls in the first instance. And I don't even know how juries handle it, because they're literally obviously having to make the call themselves. So anyway, that to me, that's where I get the most nervous.
Great, thank you. Judge Donnelly.
Well, we had a little chat about this before this session, and for me, and I think for most of my colleagues on the district court, the hardest thing that I have to do is sentence someone. That is, it is just very emotional experience for the person being sentenced, and for the person's family, and for the community in which we live, and determining what is an appropriate sentence in a criminal case, I find to be just quite difficult. And it makes you think about to what extent incarcerating someone is a solution to the problem, and to what extent you need to protect the community. You think about, as I said before, just the kind of radiating effect that incarceration can have on a family. When a district judge sentences somebody, we very often have letters from family members and friends, and they're very important to me to try to get a picture of the person who's appearing before me. In the district court, most cases are resolved by plea. And so we don't always have the opportunity to see the person in our courtrooms all that often before the person enters a plea. So the input from a person's family and people that know that person become very important. So that's the kind of difficult cases. The other part that's difficult but also fascinating is that I think other judges have referenced this before, is that we are generalists. And so every day we are seeing something different and something new, something that I've never encountered before. I was a prosecutor for 25 years. I did not really encounter patent law very often at the Manhattan District Attorney's Office. So learning about new areas of law is something that's extremely challenging and makes for long hours. But it's why we have judges one judge on our court who's going to be 100 this year, Judge Weinstein, and I think this is what keeps us going. So I hope I answered that question. I think I did.
Yes, that was great. Thank you very much. Justice Ballmer.
Yeah, I'll agree with the generalist aspect of the job is great. I had a pretty broad civil practice as a lawyer, but here we do criminal law and tax law and all sorts of civil cases, from real estate to I had an adverse possession case. The fascinating issue got into the restatement of property and the development of various doctrines of adverse possession of common law. A ton of fun. So it's a little, sometimes I sit around with my colleagues and we say, God, they're actually paying us to do this. They're paying us to figure out this issue that involves a dispute between the governor and the legislature. How lucky can we be? And we feel very lucky. I didn't practice criminal law. Criminal law, I find, and I'm glad I don't have to do the direct sentencing. Again, this is the trial courts do this, and we're reviewing it. Did they comply with the statutes? And does it comply with any constitutional limitations? But I think the most difficult cases, sort of factually, and they're very complicated legally, are the dependency cases. When can the state intervene in family relations because the parents are either unable or unwilling to take care of their kids? And when should parental rights be terminated? There are serious constitutional issues there. The facts of these are heartbreaking, but they still have to be decided in general. As Judge Ho was saying, this is the kind of case where we're going to often defer to the trial court, who has seen the people in this family. They may have seen several different children. They may have seen struggles with addiction or incarceration by the parents. And we're often going to defer to them. But there are legal standards that we have to ensure are met, statutes and constitutional provisions that have to be complied with, as well as just the heartbreak that goes on in some of these cases. I guess the other type of case that I don't like that much that we have to do, and that my federal colleagues don't, are lawyer discipline cases. Enforce the rules of the Oregon State Bar. Those are, we have de novo review, so we're supposed to really look at the record carefully. Those are sort of tough cases, but in general, most courts, certainly our court, we spread the cases around. Everybody does some of everything. We don't have a tax specialist or a real estate specialist who gets all those cases. There's the kinds of issues, they're interesting issues to me, causation in torts, damages issues in tort cases, some corporate litigation issues that, because I dealt with those sorts of things in private practice, I think are interesting. but we do the gamut, and it's always a challenge when you open. Here's a giant new set of briefs to read. I don't know anything. It's like reading for this. It's like the appointments clause. We don't have many appointments clause cases in the Oregon Supreme Court, and this was a ton of fun. But you're starting from scratch every time, so you have to be willing to sort of make another cup of coffee and sit down and dive into it.
Great. Thank you so much, Justice Balmer. So given the number of students in the audience, I think I would be remiss if I didn't ask about the role of clerks in your chambers. And so I guess I wanted to ask, first of all, sort of what role do clerks play? How do you employ your clerks? How do you interact with them, and kind of what do you want them to do with your cases? And then also, what do you look for in a law clerk? What makes a good law clerk in your chambers? So Justice Balmer, maybe you could start us off, please.
Sure. Well, we only get one clerk. That's it. We have some staff attorneys, but I hire clerks. I've had a Chicago clerk. Like the U.S. Supreme Court, we have a discretionary docket. So we have petitions for review, which are like cert petitions. And one of the clerk's important roles is going through my share of the petitions and making a record, reviewing those cases, reviewing petitions that come in, making a recommendation to me. I then either agree or disagree or write a comment on it and forward it to the rest of the court, and then writing the opinions that have been assigned to me by the Chief Justice. If I get assigned a couple cases from a series of oral arguments, I'll say to the clerk here's what the court said in our post-argument conference about how we think this ought to come out. Chief Justice Walters has a concern about this issue, but I think there's sort of a consensus around this. Why don't you start on a first draft, and we want to hear some points that people made at our post-argument conference, try and include these. We have a somewhat more complex.
Okay. Felicia, I wanted to explain to you and what I've learned in regarding to the question you asked. I'm told, this is from lawyers I spoke to and a judge, and one judge, which God bless his soul, he passed away since since this trial has been going on, but he passed away. But he was the one that was giving me information regarding certain things about what judges allow. The reason why they don't use character letters before sentencing is that it's considered to be trying to persuade a judge to rule on your behalf. But they're used at the end when the person has been found guilty as a way to lessen the sentencing time, because then they got to get a whole picture of the person so they can get see what kind of character, what people, their friends and family are saying about them. But that is not used prior to that. One way to combat that and bring in people background information is through testimonies and people coming in to testify about a person. Now, as far as Perspective was saying that she don't understand why she didn't allow good acts to come about. They said that good acts could come about if he was actually on the stand stating about, giving about what he's done and his life accomplishments and things like that. They were saying that firsthand in that sense for him to be there. Now, if it was a person who was actually there in regards to the charges and they saw something different, those testimonies were allowed. But as far as like character, things like that, he would be the one to have to talk about his character. That's what I was told in regard to the case. Since he was not getting on the stand, that part of it was not allowed. Now, if somebody was there and can say something different to what was being said by the accusers, I'm going to give an example. For example, remember where Javante said that she went into his apartment. There was 4 people there at the apartment. Now, if one of them that was in the apartment came to testify and said something different and said that, his good character, what happened, that would have been allowed. But nobody came to testify on that. You know what I mean? To combat what she was saying. Okay? Guys, you answered that? Is that a good answer for y'all? To what questions you asked? So that's my understanding of it. And I know it seems unfair, but everything is like a balancing sheet. Balancing, like you got to find where the positive and the negative is so you can match it together to find out who's telling the truth on what part. You know what I mean? And what the unfair thing is, the government had so many people to testify and not enough people on this side to testify to offset the overwhelming testimony of the other ones. You get what I mean? But they needed to be people who was actually there. Like, okay, for example, I'm just going to give you an example. Another example, like say Azriel testify, right? And then you had somebody like a Joycelyn testifying on Robert's side to offset what Azriel is saying. Because they both was there. They both can, discredit the other. You know what I'm saying by that? Okay, that's what it was. Robert did not have enough people on his side to give, his side of the story. There wasn't balance at all. So that's why the way it tilted more towards the government side than Robert's side. Okay? Let me finish playing. This is what I learned from speaking. Because I know a lot of us, we do things, we operate in more of emotion instead of understanding what the law is. You got to fight the law with the law itself. As it still wasn't balanced because that the government had so much, and it was probably intimidating that others to speak on the side. And Felicia, the other thing too, I wanted to tell you that the government was doing some tactic that was unfair. They were making threats and things like that to the other side that the other side did not want to be scrutinized, did not want their background to be checked out. Because remember, when that guy testified on Robert's behalf, what did they do? They started digging in his background of what he did, some fraudulent something. I don't remember what it was, but remember they started digging. See, the government has resources, go dig in somebody's background to try to discredit that person, right? But that's not what the person was there for. So, and the other unfair thing is they couldn't come after, the thing is they didn't know that the law in New York, you can come after the person's character, like those so-called Jane Does. You can come after their character, but they didn't do it. They treaded real lightly. And I remember when I was reading in 2008, Robert's lawyers was like, was fierce going after them. There was at one point when the lawyer was arguing with Stephanie Edwards. They were going back and forth. It became a battle. And then the judge was like, oh, whoa, stop it. That type of thing. But I didn't see none of that on this side. Kanik was going in. But that's it. Let me go ahead and play this.
An area you don't know anything about, I'll take a first cut at this one. That's the work of a clerk on a court of last resort with a discretionary docket. These petitions that we get, the cert petitions, essentially doing some of those and then doing some drafting. In terms of, I'm looking for somebody who is a good writer. Good writing is just incredibly important in all courts, but appellate courts in particular. I'm looking for somebody who can talk and is willing to talk with me about legal issues. So in an interview.
So you hear all the characteristics that what the judge looks at. Okay. If you have an attorney and I am not throwing shade on anybody, I'm just giving you guys what he just said. Okay. He's talking about a clerk, but it also goes for attorneys. If you have someone who is excellent in formulating or writing down motions and stuff like that, but then when they get in front of a person or in front of a judge, they can't articulate it or can't convey the message to the judge, it gets lost in translation, that is not good either. That is not good. Because you're supposed to be well prepared enough to be able to articulate your client's innocence through your motions as well as representing them in words. So if you're not able to be clear in conveying the message to the masses or the jury or the judge, that still become ineffective counsel. Okay? 1 second. Just 1 second. Let me finish playing this off and then we'll go ahead on. Tamiria, I'm going to send that file over to you so we can read this. Hopefully we have a chance. That was before the society started hollowing victim shaming. But you could still do it. You could still do it you could still do it. Trust me, you can still do it. I was reading about that. Yes, in the state of New York, you can still do it. It's the way you do it. You could still do it. I've been studying, y'all.
I don't really care. I mean, I care as a person, what you did last summer and, where your next trip is and what's happening in your personal life. But I want to talk to you about a legal question and have a good discussion and understand whether you are willing to engage in sort of an intellectual debate about, how should we structure, this redo we're engaging in on the way, corporate reorganization ought to be redone under Oregon law. So can you talk about legal things? And one thing, this is on your resume or your submission to a judge for a clerk application. I at least don't want to see the really interesting paper you wrote about the law of the sea, or how we ought to be dealing with climate change through international institutions. We don't do those sorts of things in our court. I want to see, the motion for summary judgment that you wrote when you're working for a law firm in some sort of, I don't know, tort case or contract case of some kind, or if you were working for the DA or the public defender. Let's see the motion to suppress that you wrote. Something that relates to the kind of law that we do. I'll end there.
Great, thank you. Judge Hope.
So I would sort of go back to what I said earlier about there are just a lot of cases on our docket, a lot of reading to do. Not just the briefs, but getting into the underlying case law, obviously reading any relevant statutes, going through records. It is a ton of work. And honestly, there is not enough time in the day to do it all, to be very blunt. And so because of the nature of the workload, clerks are critical. This job is, I would submit it's impossible to do. And it's certainly impossible to do in any way that I would feel minimally confident about without law clerks. I need people to help make sure that we are deciding every case correctly. I think Judge Donnelly put it exactly right. Every case is critically important to the parties involved. From the judge's standpoint, we see lots and lots of cases, and we try to teach. We really genuinely regard each one as we understand that they're important to the parties. But there's so much to do that I frankly do worry about making sure that we have not missed something. And so I trust my law clerks implicitly and explicitly to make sure that I have not messed something up, that I have not missed something, that we have adequately addressed every argument, that we have not missed some critical part of the record. And so clerks are not important, they're critical to the process. what I look for are, in addition to all the criteria that everybody looks for, good grades, et cetera, I think legal writing absolutely is critical, as was mentioned. To be honest, I think legal writing is something that not many people know how to do, at least not know how to do well, particularly out of law school. It's just something that really takes a lifetime of practice. But it's honestly, at the end of the day, speaking clearly, speaking in a way not like a lawyer. So to make it easy, obviously we're all lawyers, and the audience of judicial opinions is by and large lawyers. But even in that legal community, to make things as easy and accessible to understand, so that the world knows what the law is, and so citizens and entities can know how to comport themselves to the law, or at least know what the consequences will be when they don't. It's critically important to provide that easy accessibility. And so writing crisply and clearly and succinctly and to the point is essential, but frankly, much harder than people realize. And in particular, I want to hire a law clerk who knows how to push back, who is not going to just say, yes, judge, whatever you say, judge, you're so smart, judge. That's the last person I want, because, I could find somebody to compliment me. What I want to do is to find somebody who's going to challenge me to make sure that I don't mess up on these very complex cases that are too detailed and too numerous for me to be perfect on my own.
Great, thank you. Judge Donnelly.
I should start by saying that I would never have hired myself as a clerk, but so I feel very fortunate in the clerks that I have had. The most important thing to me as a district judge is to move my cases so litigants get decisions as efficiently and quickly as possible with the correct result. And with the caseload that we have, that is a big challenge. So my clerks help me to do that, make sure that there's not something that's been sitting on the calendar too long, or something that maybe in another case could wait, but in terms of the particular case has to be decided or should be decided quickly. I also rely on my clerks to give me their practical take on a case. I want to know what they think about it. And like Judge Ho, I want them to make sure I'm not doing the wrong thing. I want to make sure I haven't missed something, that I'm reading the cases wrong, that the Second Circuit is going to reverse me. And so, or that I'm just making a bad decision for the parties. So I could not function without them. In terms of what I look for, I always hire law clerks that have had some practical experience, because I think that as wonderful as the educations are that we get in law schools, once you're out in the world and you're really, putting your skills to work, I think you learn so many things that you never would have expected when you were in law school. So I look for somebody with a little bit of experience, and I look for people that are, in addition to being brilliant, which all of you are, and all of my law clerks are, that they get along with people and that they are good listeners too. And as I say, if you have a heavy docket, you've got to be able to move it, and you've got to be able to get things done pretty fast. And so somebody that can handle all that is critical to getting the work done well.
Wonderful. Thank you very much. Okay, so we have about 20 minutes left. So I think it's a good moment to open it up for questions and answers from the audience. So if you've got a question, you're welcome to raise your Zoom hand, or you can send it to me via the chat also.
Thanks, Professor, and thank you to all three of the judges for being here. I have a question. All three of you had touched in some way on the general nature of judging, and that some of you came from backgrounds that were generalists. Some of you, Judge Donnelly, came back from a background with a particular focus. And I've talked with Professor Mazur in class about how it's kind of strange that we have general judges, that we don't have a system that has, if you have a really naughty bankruptcy question, we're going to send you to this judge on the Fifth Circuit that has a lot of bankruptcy experience. And you kind of see this in a quiet way. You know, if there's a tricky bankruptcy problem in the Third Circuit, there's a good chance Judge Ambrose is going to write the opinion. Or, you know, in the Seventh Circuit, it's going to be Judge Wood or Judge Easterbrook. What are your thoughts on this? Do you think courts do this in some way that, you know, it seems that cases that play to a judge's or justice's strengths get assigned to that judge or justice? Do you think we should move to that system in like an explicit way, that we think judges, you know, should own their skills and not sort of stray beyond sort of their experiences? Just general thoughts.
Great, thank you. I'll let the distinguished three panelists answer that in whatever order they would choose. So please feel free to, you know, jump in.
I'll try to take a quick stab at it. I think it's a wonderful question, and I honestly seriously doubt that I'll be giving you an answer that is worthy of it. I almost want to think about it for a few days to get back to you. But one thought to be sure is, I think that's one of the reasons why we have multi-member appellate panels. You know, at the end of the day, we benefit as a legal system from having different voices involved, different judges to check each other, if you will, to make sure that we're getting these questions right. We don't have, by and large, an expertise-driven judicial system. Obviously, you've got the federal circuit. It's funny you mentioned bankruptcy. We obviously do have bankruptcy judges. But as you note, though, on appeal, the bankruptcy judges, perhaps ironically, are reviewed exclusively by non-bankruptcy people, but by generalists. And so I think that's for one reason why we have multi-member panels, and one reason why collegiality is so important, because we do, you know, I don't know about every court, but certainly most courts, you just by sheer fact of numbers, you'll have different people with different backgrounds, both personal and professional. And so you can kind of rely on each other. I remember some of my colleagues have made clear they like having some number of colleagues who have had district judge experience. You benefit from people without that, to be sure. But you want to make sure you have at least some people with district judge experience, because you get such an amazing insight into how rules and decisions that we make impact day-to-day litigation. That's something that if you don't have that experience, you wouldn't necessarily know. And so having a collegial bench where we genuinely respect each other and listen to each other, doesn't mean you have to agree with everybody, but you get that everybody's there in good faith, just trying to help the process. That is huge, because then you can trust that the person who does have bankruptcy experience, and we actually do have a few on our court who came from bankruptcy practices. I believe Judge Jones, Edith Jones, served on the National Bankruptcy Commission. And so it'd be natural for us to listen to her, to Judge King, people on our court with that experience, and hopefully vice versa. Hopefully everybody brings something to the table.
Judges, one of the occupational hazards is we talk too much, and so everybody can always jump in every time. But I'll jump in just for a second. I think it's a great question. That's more of a question. I sort of put that in the bucket of, well, what's your legal philosophy? I don't have a legal philosophy. Let's let the law professors in Oregon, two or three of them that actually read our cases and think about what we, what our trend is. Let them talk about that. That's a great question for a law professor, I think. As a judge, I buy into what we've got, which is a system where we do have expertise in some areas, bankruptcy, tax court. We have a state tax court judge. There's one tax court judge, and we review his cases or on appeal. They come straight to us rather than the Court of Appeals. I'm glad he's there. I'm glad he gets to sort all this stuff out like a bankruptcy judge. Many states, including Oregon, have, although we have a single trial bench of essentially like the federal district court, they're called circuit judges, but there are some that do just criminal, and it depends on whether it's a court that has 40 judges or a court that has one judge. If it's one judge, that judge has to do, in Harney County, that judge does the criminal cases, the civil cases, and the juvenile dependency cases. In larger courts, there tends to be more specialization because the law is very complex, and we do depend upon those those trial court findings, and in many cases on the expertise that the lawyers who do these dependency cases, abuse and neglect cases, termination of parental rights cases on a regular basis, day in, day out. Now, it's great that there is it's the same reason we have generalist judges reviewing bankruptcy decisions. They can get too used to dysfunctional families that they're not giving everybody the procedural protections that they're entitled to. And that's one of the reasons that we in this country, we've always had, U.S. Supreme Court and all these state Supreme Courts that essentially are generalists. Now, in some states like Texas, they've got their own criminal Supreme Court, and then what's called the Texas Supreme Court is really a civil court primarily. But I think that the law has to work for society as a whole, and I think generalist judges, particularly at the appellate level, and there's a lot of reasons to have them at the trial court level as well. But I buy into that. I think it's a super interesting question that you could have a whole seminar on it, Professor Mazur.
I don't have a whole lot to add to that. I mean, obviously the district court, we are generalists, but there is obviously a bankruptcy court. And even within the district court, judges can, at least in our district, can sign up for the patent wheel and to get patent cases. People can be on the multi-district litigation panel. And so you can make those selections. I don't know at the trial level or the district court level how practical it would be to divide cases up too finely. Obviously, as a state court judge, I did almost exclusively criminal cases. But I think on the federal level, it's a little bit different.
Great, thank you. I do think this is an especially interesting question in light of the moot court case for today, which is, of course, a patent case. And patent law is one of the areas that is most divided, most sort of sent to specialized judges, such that only one of the three of you would ever have a patent case in the normal course of your judging life. So maybe moot court is a welcome change, or maybe an unwelcome change. There's a question in the chat from Katya El-Tayeb, and she asks, in light of your very hectic workloads, which all three of you have discussed, do you have any writing tips for lawyers or soon-to-be lawyers about how to make your lives easier and how to streamline and tee up effectively the matters that come before you?
I guess I can start with that one. Yes. Don't make it too long. I have lots of requests. In every district judge has individual rules, and we have page limits. And a lot of times people will say they must exceed the page limit. And I never say no, really, but a lot of times I will say you don't have to use all this extra time. I do think that one of the keys to being an effective advocate is to be able to say something succinctly. And it's been my experience that it's much harder to do that in a shorter period of time. I don't think everybody, and I'll only speak for myself, maybe my other colleagues disagree, but it's kind of like a speech at a dinner. Nobody ever leaves wishing your speech had been longer. And I think that is pretty much the same thing with the submission. I never wish, gosh, I wish I had more. So and maybe that is not the feeling of my fellow panelists, but I feel that way.
I strongly agree with the brevity point. I've never read a brief and thought it should have been longer, and probably half the briefs I read are not terribly good, and in any event could have been shorter. In addition, I guess what I would say is, and this maybe sounds surprising to say out loud, but I wonder if some brief writers don't actually stop and think about their case before they start writing. They just start writing and then stop when they're done talking. there's a logic to these cases, right? There is a framework that the law hopefully provides, and there's a hierarchy in our legal system. Sitting and nobody should sit down and write a brief until they've thought about the case very, very deeply and really thought how best to organize it. And then once they do start writing, it should go through multiple drafts. Any important piece of legal writing should have countless revisions and drafts. One possible mental framework that I used to share with people is, imagine that you have the most important thing that you've ever wanted to convince the President of the United States to do. Okay, and it's the President of the United States, very, very busy person, but enormous power. They can do a lot to further your cause, whatever it is. I don't care what the cause is. And you have 5 minutes to talk to them, or you have 5 minutes where they will read your memo. I'm pretty sure if you were literally in that situation, you would spend untold amounts of time thinking about every sentence. You'd obsess about what word you began with, how best to grab their attention and to never let it go. You'd be trying to find a way to convince the president this is so interesting to read, at least, that they should spend 6 minutes. You get my point. I won't belabor it. That should be the approach, if you can, to everything you ever write. Because although you won't typically litigate in front of the President of the United States, you will litigate in front of people who are very busy, but who have at least some measure of judicial power to do what your client needs them to do. And so, if nothing else, think of it almost as a courtesy to the busy judge. Make it easy for us to understand what this dispute is about, what's at stake, and sort of, what individual decisions we need to make in order to decide ultimately whether we're affirming or reversing or granting judgment for the plaintiff or the defendant. Make it as simple as possible.
I don't have any tricks in the trade. As a trial lawyer, I think I wrote better and more succinctly because I knew I was writing for Judge Donnelly or for her clerk. And in state court, you knew you were writing for the judge. The judge is going to read this, and they might read it the second before they come out to hear a brief argument on it. And you have to say, here's why I should win. Here's this recent case. Here's the quote from it that shows why I should win. Short, punchy sentences, not so punchy as to be clever, but direct and to the point for a district judge. I do not have a solution for how to write succinctly as an appellate judge. I don't know if you guys were limited to 10,000 words. Is that right? I actually sent a text to my clerk last night saying, check on the federal brief length requirements because I think hours are too long. Our briefs are way too long. Now death penalty cases, we get 100, 200, 300 page briefs. But in general, especially if you're at a court of last resort, or if you're at U.S. Supreme Court or your state Supreme Court, they don't want to hear the 10 reasons that the 10 mistakes the trial court made. They want to have the one or two or three issues that are absolutely critical. At an intermediate appellate court, it's much more defensible to say you need to raise every credible thing, and in a criminal case, of course, the credible things that you think the trial court got wrong. But when you're seeking review in a state Supreme Court, or certainly at the U.S. Supreme Court, and as my colleagues know, that some of the most compressed, thoughtful writing is in the question presented in your cert petition. And if you don't spend, 2 weeks trying to figure that out, and how you're going to grab the court's attention there, you might as well, not be charging your client for that time, because there are people who are experts at this. People like Gibson Dunn or other, the solicitor's office. But I do think also that you have to print them out. I think that writing on the computer where you can forget what you said 3 pages before, and now you say it again. The amount of redundancy that creeps into briefs or into appellate opinions is phenomenal. And you've got to be able to print it out so you can see, oh, here this, what I said on page 6, I said essentially the same thing again on page 10. And you got to be ruthless in your editing, but it's very hard.
Great. Okay, so I think we have enough time for maybe one more brief question. So Alex, please go ahead.
Yes, thank you all so much for chatting with us. I've really appreciated your forthrightness. I'm wondering if you might be willing to share a moment from your career, maybe as a clerk or lawyer, advocate, time in government, that you feel informs your approach to being a judge, and maybe taught you a lesson about how to be a thoughtful and effective lawyer.
When I was in the Bronx Supreme Court, we heard all kinds of cases, felonies, misdemeanors, and at one point they had combined the misdemeanor and felony docket, which was a terrible idea, but that's not the point of the story. There was a man who was accused of turnstile jumping. The Bronx Supreme Court is the busiest place imaginable. Courtrooms are crowded. There's all kinds of stuff going on. And this man's lawyer had not come. And so, one thing I could have done was just put the case over so the man would come back another day. But I just decided I wasn't going to do that. So I appointed a new lawyer from the audience. And the lawyer was trying to get him to just take a plea to it's a violation. It's not a criminal conviction, but you have to pay a fine. It's not cheap. And the man was just sitting there, and then he said, well, Judge, I've come back here so often, and I have this paper, and the paper showed that he was using a Metro card, but he paid the subway fare. He didn't do it. And nobody had bothered. I'm not saying I was so fabulous, but nobody had checked this. And the guy had come back to court, these many times, and somebody was going to have him just plead to something so he would pay this fee. And I just remember thinking to myself, be careful, be careful when you are making these decisions, even in a case that doesn't seem so important. And it really was something that I've never stopped thinking about that case, about just that. And then, of course, it took moving mountains to get the district attorney's office to dismiss it. But that was my powers of persuasion. But anyway, it made me think, it made me realize, I think it's something I always knew, but you just have to be careful. I mean, and that's a little tiny thing, but it sort of relates to my view that, and everybody's view, is that every case means something to somebody. And so I don't know what lesson I learned from that, except that I just think about it. It's something that I always think about as a judge. So that's mine.
I want to follow up on something Judge Donnelly said earlier about judges who are difficult. When you enter whatever legal community you'll enter, I'm just going to assume that you're going to start to learn about. There's that one judge in that courthouse that nobody wants to be before. It's going to be an unpleasant experience. They're going to pick on somebody, perhaps randomly, perhaps due to some philosophical bias or whatever. It doesn't really matter for my purposes. And I've in practice seen my share of it. Thankfully, I've not been the target of it very much, but certainly seen others targeted as well. And I just vowed that is pretty much the worst thing you can do as a judge. The purpose of judging, the purpose of our legal system, is not just to resolve disputes, but to make sure that the litigants feel like they were heard and they had their chance and they won or lost, but they got a fair shot. And when you have an experience where the judge is being very, very difficult during questioning or what have you. It just leaves a bad taste in people's mouths. I actually think that there may be some judges who sort of see it as sports, sort of fun to beat up on a lawyer. And I find that, thankfully that is not by any means prevalent. I want to make that clear, but it's not zero. It does happen. And I think it's completely antithetical to what judging should be and what courtroom demeanor should be. What we're doing is trying to search for truth. At least that's what I think of it is. We're trying to figure out what the right decision is, what the law is, and what the facts are, and how do we apply it. And so it should, far from being a hostile experience, it should be a conversational engagement. There's limited time, so there are times when judges can be short, but hopefully it's not out of any sort of temper or desire to be difficult. It's just, you have an answer, but you're kind of getting off track. We're trying to get to a point. But hopefully it's as accessible as can be, understanding that the stakes are high and emotions obviously do run high as well.
Yeah, I'll tag on to that too, and again to the theme that every case is important, and just hit for a second on the importance of procedural due process and the role that lawyers play. I took a pro bono case through the Volunteer Lawyers Project or something in Portland. Somebody was being sued by the debt collector for a hospital because the hospital had taken care of her daughter who tried to commit suicide. And she had been she'd been paying like $10 a month for years. She finally lost her job and couldn't pay anymore. And they sent it to a debt collector. It turned out the daughter was over 18 when she had tried to commit suicide. The mom had no legal responsibility for the debt at all. And a law student could have figured that out. I, as a fifth-year lawyer, figured it out. And eventually, and they said, "Oh yeah, she agreed to pay." Said the debt collector, the hospital. I said, "Okay, send me the documents, and then we'll take a look at it." No documents. Go, and then I said, I'm going to ask for sanctions for this frivolous lawsuit if you don't dismiss it right away. They finally dismissed it. But I have sat as a trial judge on occasion, and I've seen how much better off a litigant is with a law student or a first-year lawyer or even any one of you compared to if they did not have a lawyer. The lawyers really, Richard Epstein told me that the lawyers are the grease that makes the wheels of not just the economy, but of society turn as well as it does. Now, God, we fail all the time. The system fails all the time, but lawyers can make it better. And I think of that person I represented in that, tiny little, it was like a $10,000 case, a lot of money to her. And we do and you do make the system work in some way. It's got its faults, but we can help improve it.
Great. Thank you very much. There are obviously more questions, but we are unfortunately out of time. So would everyone please join me in thanking our three tremendous panelists.
All right, guys, that was it. I hope you guys enjoyed what you heard and kind of got a few understanding how the judge, how they rule and how they make their decision and things like that, and get a little insight, not too much, just a little insight. I wanted to say that I noticed the side conversation that was going on in the chat, and I understand people have the right to express themselves and things like that. But if we're talking tomatoes, why are there conversation about gliding across the sky in a parachute? I'm just trying to figure it out because it's such a distraction. It causes people to try to, they don't understand why. What are they talking about? Why are they talking about this in this chat? And I think there are people who are sent to distract. Let's stay focused, because I see one of my mind was entertaining the distraction. And we should at least try to gear them back to what the conversation is about. Conversation is about the judges, how they make their decision, and how, just getting an insight of what's in her head on what's in the other judges. Just understanding the whole judicial system, how it works. There's not a time for us to debate over who did this, what marriage certificate, and all. Guys, come on, y'all. That's not what this particular live is about. Let's just stay focused. Mods set the temperature. They set the temperature. They gear people back to where they're supposed to be at. Sometimes we have to help them to, straighten it back to where the focus is. You're not supposed to allow them to take you off your game, your track. You're the temperature setting. You're the thermometer. Thermostat. Sorry, you're the thermostat, not the thermometer. You're the thermostat. You guide them to where they're supposed to be going. Because he was just coming in here as a distraction to play games. That's not. And it's always like that when we're trying to give information out, people come in to just, I don't get it. And we get in here, we get fooled by these people. All right. Tamiria, did you get the paperwork I just sent you? Did you get it? I'm gonna put the link in for you to come on in, Tamiria. Okay. What we're gonna do, we're gonna go down to the part where that attorney, all the way to the bottom, Tamiria. Here's the link. That attorney was given direction by Judge Donnelly. That part. The attorney that starts with an I. There she is. Judge Donnelly. Turn that down. Turn it down. Oops. The attorney that starts with an I. There she is. Judge Donnelly. Okay, you still got us up. Turn it down. Because I can hear it. I just took you off for a second. Okay, thank you. You got it? So I'm going to see what page we're going to start from so we can help people out to understand what happened in court. Hold on a second. Got to get it. Let me put myself in the screen. Hold on. There I am. Okay, we're not going to read the whole transcript. We're just going to read the part where I was emphasizing about what was said in court. Hold on. This is at the Curcio. We're going to go down all the way down to, I want to get the part where Let's see. You know what? How many pages? It's not that bad. Let's go ahead and do the whole thing. You want to do the whole thing, Tamiria?
Yeah, we can do it, Sylvia.
Okay, let's do it. Do we need another reader? Because it seems like there's like
yes, we do.
Parts.
It's a lot of parts. People.
Anybody else want to read?
Come on.
Where's my henny hen?
Come on,
and I know
hen.
Rhoda's working. Rhoda is working. Where's Mel? You know what? And I know red. I mean, I can't really call it red couch.
Purple couch is working.
Purple couch is working.
Mel's working.
Let's see where Mel is at. Oh, the Curcio. We're reading the Curcio, Felicia. I just change my voice and be whoever. All right, let's go.
You gonna have me laugh and see?
All right, ready?
Yes. What? Okay. We're gonna start from the beginning. Oh, it's 66. Oh Lord. Okay.
You said it.
Oh wow. Okay.
And I'm gonna say who they are, so you guys don't get lost of who it is, if just in case I can't change my voice the way I'm supposed to change it. Okay. All right.
We're gonna start on page 3, or
Yeah, page 3. In open court, the Honorable Ann M. Donnelly presiding, defendant present. Okay, here we go. This is the criminal cause for Curcio hearing, docket number 19 CR 286, U.S. versus Robert Kelly. Counsel, state your appearance. Government first.
Good afternoon, Your Honor. Maria Cruz Menendez and Nadia Shatata.
Nicole Blank Becker on behalf of Mr. Kelly, seated on my left. Seated on my right is Attorney Devereux Canick, and my far left is Attorney Tom Ferranella. Thank you, Judge. Good afternoon.
Alana Haramati.
Okay. Good afternoon. Steve Greenberg, Michael Leonard on the phone. Thank you. I think we have Miss Rodriguez as well. Is that correct?
Yes, Your Honor. I'm present in your virtual courtroom.
Okay. I just want to make sure everyone can hear. Just a quick outline of what we are going to do today. Parenthetically, I get Mr. Canick's letter, which I will address at the end of today's proceeding. This is a continuation of the Curcio hearing we began on the 17th.
I'm sorry, that's my husband trying to call him.
Okay.
You go ahead and read that.
Okay, yeah, here we go. Let me see something. I got a text message. Hold on. Okay. This hearing is taking place pursuant to the court's obligation to investigate whatever, quote, the specter of attorney conflict of interest arise. In connection with today's proceeding, I have reviewed all the submission and that I've gotten, not just since before June 17th, but also those that were submitted after that hearing. I'm trying to be like the judge, Lady Coltrane. Sorry. I'm just going to remind everyone that I am not here to mediate disputes. Hear that? Y'all hear this, y'all? This is the judge talking. Okay, so you coming in? I'm going to send it to you. Hold on. I got to read it. Hold on. I hope I got to read it. Hold on. Let me see if she answers. Just hold on, y'all. Hold your horses. I am trying to get an answer. Okay, hold on. Gotta send the thing over. Just hold on a second, y'all. All right. Hold on a second. Sorry, guys. I apologize. Woosah. Hold on, y'all. I gotta mute myself for a second. I gotta listen to the voice message. Hold on. Okay, guys, y'all ready? All right, let me go ahead on with my voice. Let me go ahead with my voice. Okay, we are ready? All right, where am I at? Okay, she says she doesn't want any conflict. She says this hearing is taking place pursuant of court's obligation to investigate whenever quote. Okay, we did the conflict of interest. In connection with today's proceeding, I have reviewed all the submission and have gotten not just since before the 17th, but also that were submitted after that hearing. I am going to remind everyone that I am not here to mediate disputes among the lawyers. Y'all hear that? She's not here to mediate disputes among the lawyers. I'm not interested in anything that's not related to the discretion issue to the extent to which it is. And I think it's only Ms. Becker at this point who may have a conflict. I don't care when Mr. Greenberg met Miss Rodriguez. I have no interest in anything that has to do with that. I'm only interested in the extent in which where the conflict, because Mr. Kelly, listen to this is what she said. Mr. Kelly has a right to have conflict-free representation. And if he is going to waive it, he is entitled to know what conflict is and have it explained to him. Y'all hear? Are y'all listening to what I just said, what the judge said? Are y'all listening? Are y'all listening?
I'm listening.
You heard that, right? Should I repeat it?
Yes, say it over.
She's not interested in them fighting. She's not interested in all this extra stuff that's going on between these attorneys. All she cares about is Mr. Kelly, that his rights are not being violated, that he gets the right representation and conflict-free representation. I'm going to read it directly from her words right now. Okay. I have reviewed all of the submission that I've gotten, not just since before June 17th, but also those that were submitted after that hearing. I am going to remind everyone that I'm not here to mediate disputes among lawyers. I'm not interested in anything that does not relate to the discrete issue of the extent to which it is. And I think it's only Miss Becker at this point may have a conflict. I don't care when Mr. Greenberg met Miss Rodriguez. I have no interest in anything to do with that. I am only interested in the extent in which there is a conflict because Mr. Kelly has a right to have conflict-free representation, and he if he is going to waive it, he is entitled to know what the conflict is and have it explained to him. Do the people in the back hear that? Do the people in the back hear that? All the ones that was trying to be funny and it was the attorneys, people, not the judge. Are you hearing this? It was the attorney trying to throw mudsling at each other. This one did this one. This one met this one that time. This one. She said, I'm not here for that. Nope. I'm here to make sure Mr. Kelly's rights are not being violated. Are you hearing me? Tamiria, do you think they heard me?
I hope they did. I can hear you loud and clear. I'm reading it right off the paper. You reading it right off the paper.
And she says, as I said before, I appointed Miss Haramati as a Curcio counsel. I appointed Miss Haramati as Curcio counsel. And I thank her for her effort in regards to this, to advise Mr. Kelly about potential conflict. And we will talk about it in a bit. Do y'all hear that? Thank you. T. Glenn said yes. T. Glenn. No, I wasn't yelling at you, but T. Glenn. I was yelling at the folks in the back. So that's what she said, okay? People have it in their mind that, the judge is this, judge is that. She may be, but her interest is what the law says in his protecting Mr. Kelly's rights. If his lawyers did not have an interest in protecting Mr. Kelly's right, that was the judge's job to try to do that. Okay? The judge was letting R. Kelly decide to waive his right or not. Said that he waived his right. Okay, go ahead, Purple Couch. Purple Couch, go ahead. Speak it. I'm about to read it for you. I'm about to read it. And I'm about to read what Judge Donnelly said to Mr. Kelly. She kept asking me, "Are you sure? Are you sure?" Let me tell you, if you choose her, she's gonna, okay, I'm gonna read it so y'all will know. Okay, hold on. So is the y'all sitting here putting the blame where the blame is not. Put the blame where the blame's supposed to be at.
Yeah.
All right, let me finish.
Sad, but it's the truth.
It's sad. It's sad. It's sad because there was attorney placed in that position to help him understand, and she spent what 4 hours in the back room trying to explain it to him.
But somebody was in his ear. His own attorney. She knew better.
Okay. Let me clear the air here. Hold on. All right. As I said before, I appointed Miss Haramata as, I don't know how to say her name, but I'm just probably screwing the lady's name up. I apologize, but that's what I think it is. All right, as Curcio counsel, and I thank her for her efforts in regards to advise Mr. Kelly about any potential conflicts. We will talk about that in a bit. Including in the submission I have received were an email and some other materials from Ms. Rodriguez about this. Now, you know, Ms. Rodriguez came to the Curcio hearing to tell what happened, what was going on, right? She came to explain everything to the judge and all that, okay? And I included in the submission. Okay, I'm sorry. Let's go down. Okay, Ms. Rodriguez, about this possible conflict of interest related to the two witnesses. I am going to remind counsel there is one witness that we are referring to, Jane Doe number 5. Do not use her name. She is to be referred as Jane Doe number 5, but I do have some questions for Ms. Rodriguez regarding some of the material that she submitted. Some of those questions will, in all likeness, implicate the attorney/client privilege. Her representation of these two witnesses, and for those portions that do involve her attorney-client relationship with Jane Doe number 5 and the other witness. I will have a conversation with her ex parte. Okay. Some of the inquiry that I have of Miss Rodriguez, I think we can do in open court, but I'm going to ask Miss Rodriguez to let me know to the extent to which anything that I am asking or that she may want to discuss implicates that privilege. And so I want to make sure. Miss Rodriguez, you haven't been here before, but we are referring to one of your clients as Jane Doe number 5, okay? Tamiria. She's not paying attention. Oh my God, she's not paying attention. She's not paying attention.
I'm sorry. You haven't been here before, but is it me? Oh, yes, Your Honor. I'm sorry. Don't do that. I'm sorry.
Guys. She wasn't paying attention.
I wasn't. Sorry.
And then let's go back. Okay. You said yes, Your Honor. Okay. Mm-hmm. And then I think we are referring to what other witnesses. Her name is Miss Savage. Is that correct?
That's correct.
Is there anybody else that is to be referred to as Jane Doe?
For the purpose of this discussion, I believe that's it, Your Honor.
Okay. Ms. Rodriguez, I'm going to ask some of the questions that we talked about in open court. And if these relate to subject that will involve discussion that are privileged communication, let me know, okay?
Okay.
When were you retained by Jane Doe number 5 and Joycelyn Savage?
I was retained by them in July of 2019.
For how long?
And the exact date, I'm sorry, I was looking for the exact date, but it was very early July 2019.
Okay. Now, how long did you represent them?
I represented them jointly until about September 1st of 2019.
When did you first come in contact with Miss Becker?
I first met Ms. Becker in person at the bond hearing that was at the Dirksen Center in July 2019.
At what center?
The Dirksen, the federal building in Chicago, is called the Dirksen building.
Dirksen? Okay. And what was in connection with representation of these women?
It was because, yes, I would say yes.
And at that point that you met Miss Becker, were you representing Jane Doe number 5 and Miss Savage the first time you met her?
Yes.
Did you ever give Miss Becker any instruction regarding her interaction with those witnesses?
Yes.
And what were your instructions?
I had asked her to please not contact my clients without my knowledge.
And what form?
And I also,
Go ahead, I'm sorry.
I'm sorry. I know there is a delay, so I am trying to speak slowly so you can all hear me.
That's fine. That's fine.
The second one was to please not give them any advice about things that might pertain to the case or their interests.
And in what form did those instructions take?
The form was through text message and through emails and through in person.
And do you know approximately when you gave those various instructions?
Yes, and actually on the phone, I spoke to her on the phone. So on July 15th, I sent her a text message with my email address and called her, and we had a very lovely conversation, and I communicated to her.
And what did you say?
I don't want the line to be blurred I said specifically, I don't want the lines to be blurred regarding our roles, and I think they are already blurred. If you could please not contact them at all without my knowledge.
Did you text it to, sorry, let me finish the question. I know you have a little bit of delay. Did you text that or emailed it? Did you say it in person? Did you do all three of those things?
Yes, the text messages was sent on July 15, 2019 at 5:15 p.m. Then the phone call with Miss Becker was later that day, and we spoke for about 45 minutes. Then I saw her on July 16th in person. I met her at about 1 right before the hearing, and we discussed it, and it was very pleasant. She seemed to have understood what I was asking her to do.
You said she seemed to understand. When you met in person, did you receive any response to the text message you sent her on July 15th?
No.
And there was a way to tell when you sent a text message whether or not a person received it?
Not through the technology that I had at the time.
For example, would you your phone tell you if a message did go through?
No, I wouldn't. No, it wouldn't. But I saved the text message on my device, which I still have, and I have it in my hand.
Okay. I think it may be included in some of the material that I received. So you still have it on the phone, is that correct?
Yes.
So sometime when people send text messages, it doesn't go through. You get an alert that tells you it didn't go through. Does your phone do that?
Yes, it does.
And did it do it at this time that you sent the text message? Is it in 2019?
Correct. 2019. It did not. I'm sure she received it because we spoke after that text message.
What specifically did she say that led you to the conclusion that she got the message?
On the phone, I received her saying, on the phone, I remember her saying, Gloria, I'm glad they retained you. I'm glad they retained an attorney. I'm Mr. Kelly's attorney. Whatever you need, the lines are drawn, and I'm not going to step on your toes. And she made it known that there was a clear understanding of my concern.
So, this was July 16th?
July 15th. The phone call and the text message was on July 15th.
And you met her in person on the 16th when you had this conversation, correct?
Correct. And I actually met her and Mr. Greenberg in person for the first time July 16th.
Following those contact on the 15th and the 16th, did you also say that you sent an email?
In my notes, I saw that I put an email there, but I don't think that my office maintained a record of that. So I don't independently remember sending an email. I had a little note there that said I sent an email, but I don't actually have the email.
Okay. Now, following these conversations, did you learn at some point that Miss Becker was contacting both of these women without letting you know?
Yes.
And how did that happen?
Well, Jane Doe number five was kind of the point of contact for Miss Savage. And it was obvious to me that despite the lovely conversation that I had with Miss Becker, that Miss Becker was still relaying to them information about Mr. Kelly's case and giving them what I believe was legal information, which was contradictory to what I was advising them on.
All right, go ahead. Sorry.
And I can give you, sure, specifically there was an interest about what to do with the media. And I remember asking them, where are you coming with this? And their reply was, Ms. Becker said. And then I have no doubt in my mind that Ms. Becker was continuing to speak to my clients. Number one, without my knowledge, and number two, relaying information that was of a material nature in response to their legal interests.
Now, I want to find out what specifically that information was. But it sounds to me like it requires you to divulge conversation that you had with your client that are privileged. Is there anything you could tell us?
That's correct, Your Honor.
Is there anything that you can tell us about that's not privilege? If you can't, that's fine. We can.
Yes, the breakdown of my relationship with both of my clients, I believe was encouraged by them still receiving information that was contrary to my advice for them. And when I formally severed the relationship, I received instructions in a letter from my clients signed by both of them seeking to turn my file over to their new attorney. The new attorney was not named in the letter, but when I spoke to Jane Doe number 5 and asked her where she wanted me to send it to, she gave me Miss Becker's contact information. And then I had a discussion with her about that and how I felt that it was concerning to me that she would be representing them.
Is there anything else that you can tell us? Put quite a bit information into your submission. You put quite a few bit of information in your submission. Is there anything else that you can tell us that's not privileged that's relevant to this inquiry?
I believe that would be it as far as what is not privileged.
Okay. I think that's at this point we will recess so the court can do inquiry ex parte on the topic have to do with the attorney-client privilege. I don't think that we will take that long, but I'm going to leave the court to do that, and we will recess until we are finished with that. Okay? Miss Rodriguez, can you hear us?
Yes, Your Honor, I can.
I spoke with Miss Rodriguez about the communication that implicates the attorney-client privilege. There was one item or one incident that the witness described that I think is appropriate. It does not implicate the attorney-client privilege. So I'm going to ask the witness to describe the conversation prior to court speaking with the witness ex parte. The witness described a conversation that she had with Miss Becker on the 16th of July. I think that was the date. Following that conversation with the witness, during ex parte of the inquiry, we talked about a conversation that you had with Mr. Greenberg regarding and your concern about Miss Becker. Can you describe the conversation?
Yes, Your Honor. About a couple of weeks after the federal bond hearing in Mr. Kelly's case in Chicago, I had spoke with Mr. Greenberg about a different issue on the phone, and it was a very brief conversation that I'm sure Mr. Greenberg may not remember. But in the conversation towards the end of this conversation, I had mentioned to him if he could please talk to Miss Becker to quote rein her in, and the response that Mr. Greenberg said, it was something to the fact of good luck with that.
Okay, that's not funny, but dang, he's saying good luck with that.
Good luck with that. Trying to tell you. Ooh, to do right.
Okay. When you say rein her in, I just want to be sure. What do you mean rein her in regarding what?
Rein her in respect to not communicating with my clients without my knowledge.
Okay.
It was apparent to me that Miss Becker continued speaking with them regularly, and that my communication with Miss Becker to please stop went unheeded. So I took my concern to Mr. Greenberg, since I knew at the time Miss Becker was on Mr. Kelly's legal team, to ask him to please rein her in from continuing to that behavior. And he said something to the effect of good luck with that.
Okay. I don't have any further question for the witness. Let me start with the government. Are there any additional question that you want to put to the witness, or you want me to put to the witness to complete the record on this issue?
No, Your Honor.
And now, how about Mr. Kelly's side? Any question to put to the witness regarding the issue that I am interested in? I will put the question, but you tell me what the question is.
I actually just have.
This is Nicole Becker.
Oh,
Okay.
who's gonna read it? Me?
You go ahead.
Oh,
Yeah, I
okay.
just want to tell people who it was speaking.
Oh, okay. I actually just have things that I would like to address to the court. They're not specific questions to Mrs. Rodriguez. Thank you.
All right. I think it's probably okay. It is. Let me go. Let's let the witness go.
The government has no objection to that.
All right. I want to be sure that Curcio's counsel is there anything you want to hear from her?
No, Your Honor. I don't know how
And
to change my
nothing
voice.
you gotta do. No, Your Honor.
Okay.
And nothing else from Mr. Kelly's side we need to put to the witness?
No, Your Honor. Thank
No,
you.
you said no, Judge.
Oh, I'm sorry. No, Judge. Thank you.
Thank you very much, Miss Rodriguez. You are free to go.
Great. Thank you, Your Honor.
Okay. Now, I will hear from the parties. If there's anything additional, any additional things they want me to look at, anything else that they want me to say. I don't know, Mrs. Becker, if in the time since that conference in June, you have, hold on, y'all, listen. You have had a chance to refresh your recollection about the matter at issue. Is in this hearing, or if there's anything that you want to say, bearing in mind that the focus of this hearing is Mr. Kelly's right to conflict free counsel. As difficult as these inquiries are, it's not about, unless it's factual questions about, it's not about you. In other words, it's about whether there is a conflict, and I will repeat, it's all not about whatever dispute or disagreements you have with Mr. Leonard or Mr. Greenberg. Keeping in mind, this is something specifically you have to add.
Thank you, Judge. Judge, and I don't mean to be belabor the point, but I think it's appropriate for me to make a record as well as just forward my thoughts. Judge, I did have a chance to look at the messages that were sent on the piece of paper that was given to us from Ms. Rodriguez. Obviously, it does show that she attempted and or did apparently. She can't even tell us.
Did you get it?
Yes.
Did you get it when it was sent? That's the question.
Judge, unfortunately, I have zero recollection of seeing it. It doesn't mean I didn't get it. It just means I have zero recollection of seeing this.
What is the question? What was going? What?
It's you say okay.
Competent. Okay. No, I was reading the question. Sorry.
Okay.
But did you get it when it was sent? That's the question. Oh no, I gotta go back up. Sorry.
Okay.
Okay, wait, say read your part again. Read your part
Judge,
again.
unfortunately, I have zero recollection of seeing it. It doesn't mean I didn't get it. It just means I have zero recollection of seeing this.
Okay.
Thank you. Additionally, Judge,
Now listen to this part.
What I provided for the court, since I had an opportunity to review the material that I had specifically pertained to Mrs. Rodriguez and or my communication with the girls.
You hear that, right?
Mm-hmm.
The women. That's what the judge said.
I'm sorry. Go ahead. I'm sorry.
They are women. They were adult women.
The women. You are correct, Judge. I apologize. Judge, my research based on text messages that I was able to look through, Judge, and I supplied this to the court, simply showed that on July 13th, Jane Doe number 5 sent me a text message indicating that she hired a spokesperson, and that spokesperson was Mrs. Gloria Rodriguez. So I was made aware of that on the 13th. And then on that particular day, I also had some conversations. That text message conversation with Mr. Greenberg, and when I had conversation with Mr. Greenberg, he was asking me if I would ask the girls if they were coming to court that day.
I'm going to stop you. I'm going to stop you.
Sorry.
It's 2021. We are talking about women in their 20s. They're not girls. Please do not refer them that way.
I apologize, Judge. It's been 2 years.
Now, y'all, hold on.
What
The
that
judge
mean?
is telling his attorney, stop calling those women girls.
Wow.
The judge is telling his attorney, stop calling those women girls. Not only once, she kept chastising her. Now, this is
Wow.
the excuse. This is the excuse that she used. Go ahead. Go ahead, read it.
She said it's been 2 years.
Go ahead.
They were women then too. That's what you supposed to say, Yana.
Oh, hold on. You didn't finish.
I did.
Yeah. No, you said it's been 2 years.
Judge. It's been 2 years.
There were women then too. Go ahead.
The discussion was about women, was about the women in the text message. He had wanted me to contact them, and specifically, I indicated to Mr. Greenberg, and this is in the text message. They said they are having Gloria Sherman be their spokesperson. Apparently, she told them she had lunch with you the other day. So this would have been prior to July 15th. I am sure they would like to come to the hearing. Do you think they should? And what time? And his response, Judge, was, people talk too much. We had a meeting in a secret location so nobody would know. Wow.
Did y'all hear that? Okay, let me repeat that what you just said again. Hold on. People talk too much. What?
I am sure they would. What? She said I'm sure they would like to come to the hearing. Do you think they should, and what time? And his response, Judge, was, people talk too much. We had a meeting in a secret location so nobody would know.
All right.
Wow.
Okay, my glasses got blurry for a minute.
Go ahead and say what the court said.
Whoa, I can't even see. For real, y'all.
Goodness. Okay, you all right?
Hold on, let me get my thing together here. Hold on, I gotta put it all far away from me. All right, here come what the judge says. What does that have to do with your? Hold on. I'm so sorry. Judge is going in, y'all. Hold on. Let me read what Judge said. Hold on. She said, what does that have to do with your communication with these two represented witnesses?
It does, Judge, because if I could finish that sentence.
I read it. You submitted it, so therefore no reason to keep reading it.
Just for the record?
It's on record.
So Judge, Mr. Greenberg told me that she couldn't represent the women. Okay. So although I knew on my own from conversations with Ms. Rodriguez that she was going to represent them.
She said, go back to what meeting? Hold on. She said, go back. Perspective, you want us to go back to the meeting part?
Go back to the meeting, huh? So
Oh, she said, huh? Okay. Let's go back. Okay, let's go back.
Okay.
Get to the front, the secret
She was
meeting.
trying to tell on Greenberg, tell people what they doing and stuff.
Go ahead. Let's go.
I don't even know where it's at. Hold on.
All the way up to number 3.
Okay, she said, I'm sure they would like to come to the hearing. Do you think they should, and what time? And his response was, people talk too much. We had a meeting in a secret location so nobody would know.
What does that have to do with your communication with these 2 represented witnesses?
It does, Judge, because if I could finish that sentence.
I read it. You've submitted it, so there's no reason to keep reading it.
Just for the record?
It's on the record.
So, Judge, Mr. Greenberg told me that she couldn't represent the women, okay? So, although I knew on my own from conversation with Ms. Rodriguez that she was going to represent them.
But that is, I'm sorry to sound impatient, but the question is whether you knew, and you said the last time that you did know that she represented them. So that is why I'm not really interested.
Sorry. Oh, I'm sorry. Go ahead and read.
Oh my God. She is go off the chain with her. She said, I'm not interested. Mr. Greenberg wants to get off the case. If he were on the case, I would ask him these questions. But my intention is to excuse them. So that is why I'm not trying to explain it to you. Maybe there is a forum that you all should hash out your complaints about one another. It's not here, okay? I don't want to know about it. A, because I think it's a waste of time. And B, it's not focused on what I'm focusing on, which is your client's right to free conflict. Wait, hold on. I gotta go back to her. Hold on. A, because I think it's a waste of time. B, it's not a focus of what I'm focusing on, which is your client's right to conflict-free representation. I think if we keep our eyes on the ball of what Mr. Kelly's interests are and not our own personal interests, we can accomplish the objective. All right, Judge Ann Donnelly. Hold on, let me finish reading. Hold on, y'all. Maybe there's a place that you all to argue about Mr. Greenberg said or what someone else said. But I think it's clear that you were aware at the time that Miss Rodriguez was representing the 2 women. Correct so far?
That is correct, Judge.
And I think the last time we also established that you were able also to rule that the lawyer could not speak to represented people.
That's correct, Judge. And that's why I'm trying to make this record, Judge.
But whatever Mr. Greenberg said isn't part of the record. I'm encouraging you to focus on these things. That's my question. My question is, in your review of your material, is there anything that you want to add about your interaction with the 2 represented women in connection with this case?
Yes, Judge. With all due respect, I do understand exactly what you're saying. So thank you, Judge. The reason I brought this up is simply because even though I strike that, I knew that they were represented. Therefore, the same exact day when they text me, I supplied the court with text that I responded and said, "Ask Gloria." That was on July 13th. There was a number of texts between July 13th and July 16th that I did not respond to. And on July 16th, I text them back, "Ask Gloria." And ultimately, Judge, the very next day, the 16th, that's when the women sent me an article which is produced for the court as well. And they indicated that in their text message that as a result of the article that was on a social media outlet, that they did not want her as their lawyer anymore.
They told you this?
In a text message, yes. Judge, yes. Yes. And that was the following day after Mr. Kelling's hearing.
So, it is your position that you thought at the time she was no longer representing them?
I actually still thought she was doing the media stuff with them. Yes, I actually did. But they accidentally, and I think I brought this up last time, and it's in the text message as well. They accidentally ended up sending me the termination letter. And so I had a chance to read it because at first I didn't know what it was, but it stated something. I mean, it stated saying, "Hey, Gloria." It started saying, "Hey, Gloria."
I know that. What it said. Is it in the record? I'm sorry.
No.
I know what it said. It's in the record. And we talked about that the last time. But it is that case. It is the case that you continue to have significant contact with them and conversation during this period. Is that true?
Judge, I had no significant conversations, but I answer if they would say what day is court or something to that effect? Did I have significant conversation as has been indicated somewhat by Mrs. Rodriguez about legal stuff? Never.
Did you have a conversation with them about having to do with this case?
Yes, I would give them what date if they would ask, Judge. I believe on one point they asked if he needed clothes, a suit for court. I responded to that. There are several things of that nature that I did respond to. Yes, Judge.
Did you talk to them about their relationship with Miss Rodriguez? Did they share with you their thoughts about that?
Judge, the only thing I recall them talking about is the message when the article came out that they want to terminate her. That's what I recall.
Okay. Is there anything else you want to put on record? I'm not trying to keep you from putting anything on record except to the extent that it has to do with a personal dispute between you and the lawyers. I'm not interested in that unless it has something connected to this issue, but I think it does. I don't think it does.
Judge, I was simply trying to put a full picture as to what my understanding was. And other than that, Judge, I do not have anything additional. Thank you.
Okay. What about any co-counsel have anything you want to say on this topic, Mr. Farinella?
No.
Mr. Canick?
No, Your Honor.
From the government?
Very briefly, and I believe we spoke about this last time when the government spoke with Jane Doe number 5. She she did detail a meeting in approximately August of 2019 in which she had a lengthy conversation with Ms. Blaine Becker. During that conversation, I believe there were questions.
Hold on a second. Perspective said not enough information was given to show the conflict. No, the information was given behind the scene. We didn't see it, but the judge saw it. It was pretty lengthy. Rodriguez wrote the whole thing out and also other information. We just didn't see it. Okay, go ahead. Sorry, Tamiri.
Okay, Jane Doe number 5. Okay, Jane Doe number 5. She did detail a meeting in approximately August of 2019 in which she had a lengthy conversation with Ms. Bland Becker. During that conversation, I believe there were questions concerning her relationship with the defendant and information that Ms. Blaine Becker thought might be useful for the purpose of Mr. Kelly's defense. Some of which information, as we stated in our filing, could be perceived, and I think frankly would be perceived adverse to the defendant's position at trial. Wow.
It was. That's why she wasn't able to cross-examine her.
Right. Wow.
There's a lot of stuff. So just because we were not privy to it doesn't mean it didn't happen, because it had to happen because she was not allowed to cross-examine. So that basically hindered Robert's case.
Yeah.
Yeah.
Mm-mm.
Yep. So because he didn't have Nina Gina is basically stating what
present,
because it did violate, it is in violation of his Sixth Amendment, because she withheld information that stopped him from having a full representation. She couldn't, because she had let me shut up. As I drink my water, let me mind my business. Okay, I'm just gonna give y'all facts. Do you recall that meeting? Do you recall that meeting, having conversation with them in an interview? Is it just Jane Doe number 5? Huh? I'm on number 20.
Oh, you're supposed to be on number 10.
Oh, I'm sorry. I jumped down all the way down. See, you got me confused with all this stuff.
I didn't do that.
Okay, number 10. I want to be sure I understand what you're saying. The information that the witnesses gave to Ms. Becker, are you saying would be
adverse to the defendant's position at trial?
You see, that's not fair. Adverse, meaning that. Okay.
Adverse people to the defendant's position at trial. And I only raised it for the purpose of making it clear that.
Hey, wait a minute. Perspective. Listen, she said, but he had other attorneys. She couldn't have passed it on, because that information that she had could not be passed on to the other attorneys. Could not. She had to hush it, because once she got that information, she couldn't share it with. That's what causes his inability. That became adverse to him, because she could not open up her mouth and tell any information she gathered from them. Because what would happen is, if the other attorneys got that information, Jane Doe number 5 said, I spoke to Nicole about this. How did this one get that? That's how it's a conflict. It was a problem. She couldn't reveal anything she got from him. She couldn't reveal it. She could not reveal it. Because how else, if say she decided to give it to Canic or whoever that's going to cross-examine, if she knows she gave it to Nicole at the time, and say that the information is in the documents already, now Nicole turn around and give it to Canic or give it to whoever it is. You get what I'm saying? Okay. There we go. I got it. Go ahead on, ma'am. Where did she go?
I'm sorry, I got a phone call, girl.
Go ahead.
So wait a minute. So okay, advice to the defendant's
adverse.
I'm sorry, adverse to the defendant's position at trial, and I only raised it for the purpose of making it clear that to the extent that your question was, did Miss Blaine Becker, have any lengthy conversation with the witnesses? My understanding, based on conversations with Jane Doe number 5, is that there was at least that meeting in the approximately August of 2019.
Do you recall that meeting, having conversation with them in an interview? Is it just Jane Doe number 5?
I believe Miss Savage was present as well. Judge, I cannot honestly recall. Did I have conversations with them? Yes. But did I know about their history with my client? For a long time, they were not represented by anybody. So I certainly did have conversations with them about their relationship, kind of, I would say, but I certainly cannot specifically remember a conversation in August of 2019 where we talked about any specifics or that I gave them any advice adverse to Mr. Kelly.
I do not think that's what Miss Cruz Mendez is saying. I think what Miss Cruz Mendez is saying is that during the course of that conversation, Jane Doe number 5, listen, y'all, gave you information that was not helpful to your client.
If it's helpful, I can point both the court and counsel to where we indicated in our letter. I will find that.
Is that the letter of June 24th?
The June 24th letter, Your Honor. Your Honor, it's page 3, the first full paragraph. Judge, may we approach if that's appropriate? That's better.
I do not really see any need to approach at this point.
Wow. She didn't want them to hear it.
Woo, child. Woo, child. We're just talking about this paragraph. I take it you received that letter, correct?
I received all the letters that were on the pacer. Yes, Judge, of course.
You're doing what
I'm
you're
sorry.
doing that to alert Miss Blank Becker of what you're talking about.
That is correct.
All right. My recollection was that you said you met them, Jane Doe number 5 and Miss Savage, I think it was at the hearing after Mr. Kelly's arrest on the Illinois federal charges. Is that correct? That was my recollection of the testimony, or maybe you had talked to them on FaceTime or something before then.
Judge, I do recall that they were at Dunkin' Donuts one day. They were dropped off there prior to court, and
I'm talking about the first time you met them.
oh, I'm sorry. The first time, yes, Judge, it was. I had a FaceTime call with my client months into representing him, and he had turned the phone, and I had said hello to them. Yes.
Hold on, y'all. Sorry, phone call.
check. Hold on, I gotta check. Hold on, Sylvia, 1 minute. I need to make a phone call.
Okay, Tamira, you ready? Sorry about that, guys.
1 minute, Sylvia. 1 minute.
I had to take that call, y'all. Even though the appointed attorney talked to him, Becker probably assured him that there was no conflict. Yeah, Lady Earth, I don't think they really told him exactly. I mean, I'm talking about Becker. That's what I'm saying. I don't think she really told him exactly what was going on. I think they told more of the legal part of stuff, Yep. Okay. Purple Cow says she could have ordered Nicole to remove herself without Curcio based on what she received in the testimony, and she went with routine, believing she was within the rule of law. Oh, wow. Well, hold on, y'all. I'm waiting for Miss Tamiria to come back to us. My apologies, y'all. I had to get my water down. Got to still get more water down. Yeah, guys, I'm getting text messages. Folks are pissed right now. Folks are mad because we're reviewing some of this stuff and they're like mad. They mad at what's going on. They mad, y'all. They mad. Not mad they just upset because Robert was not treated well with his own attorneys, y'all. That's not good. That's not good, y'all. That's not good. And all I'm doing is what? Reading what? Transcript. I'm reading the transcript. I ain't reading nothing else but the transcript. It's not my opinion. I'm just reading y'all facts, what happened in court.
Okay, Sylvia, I'm back. People want to call as soon as I get into this. Okay.
Hold on, I think Mel is coming back now. She's ready. Hold on.
So we on line.
Hold on. I think Mel's ready. Hold on. She says she's.
Okay, I just want to know what line we on.
Oh, she's working on her presentation. All right, she's working on her presentation for class. So
Okay.
I'm glad Bronjean brought this out. Yeah, exactly. And my point exactly. She had a power to override. She went with the routine instead. Yeah, but I'm gonna give y'all, and I think what happened is, let me. What people didn't do their homework. That's what I'm gonna say.
Mm-hmm.
People didn't do their homework. People hid stuff from Rob. All right, you go ahead on your part. I think it's up to you. I think your turn. You were reading.
Hold on, I'm trying to now this thing. Yes. Am I a yes or which one? I'm sorry. The first time, yes, Judge, it was I had a FaceTime with my client months into representing him, and he had turned the phone and I had said hello to them. Yes. That was line 17.
17. Okay. Now I'm 18. Okay.
Yes.
So you never had any interaction with them, correct?
Yes.
And prior to them being represented by Miss Rodriguez, you hadn't had any or did give them any advice whatsoever?
Judge, the first time I was contacted, I believe I supplied that to the court as well, was I have to look, but I believe it was July 12th or 13th by Jane Doe, number 5.
Hold on. Miss Alvera, you said why didn't Kanik explain that to Kells? Kanik was not even there at the time. The judge gave Robert an attorney to explain that to him. Kanik was just coming into place. He was somebody just new coming in. Remember, this is when he gets introduced into becoming an attorney on the case. So it was not Kanik's responsibility. It was the responsibility of the attorney that was given to him. Yeah, that was because that's why the judge appointed an attorney to explain to him what was happening, and
he was confused. He didn't know what was going on. He's going off of his lawyer said she didn't do it. You see what I'm saying?
Yeah, but we're gonna read some more to you. It's gonna be a little clearer. The lady's part, what she said to him, and you're gonna hear what Robert says to the judge and all that. The judge had to reiterate, had to ask it a couple of times, and she even told people it's not funny because it's lawyers have difficulty in understanding this. So let's not think this is a just a him thing. It's even people that's well versed in this.
I don't understand it, so I don't.
Yeah.
It's nothing about R. Kelly.
Okay, so where are we? 17.
We on the next. We on 1.
Number 1. Okay.
Yeah, we on 3. Number 3. You on
number 3? Okay.
28.
And so prior to that, have you had never, during the course of your representation of Mr. Kelly, you hadn't had any interaction with them at all in the nature of legal or any advice, just bearing in mind that I think it's not just, even if it's how to deal with the media, that is something that is also under the umbrella of legal advice because of someone's interest in how they perceive publicly. So I'm referring to that as well. Nothing else.
Judge, I may have seen them in court prior to that, but me personally interacting with them, that is correct.
Is there anything else the government want to add?
Not with respect to this issue, Your Honor.
And anything else from the defense?
No, Judge.
Ms. Haramati, anything from you?
No, Your Honor.
Let me ask Ms. Haramati, do you need to talk to Mr. Kelly any further? There is one thing I want to place on record that is based on my conversation with Ms. Rodriguez. And after that, I want you to tell me if there is any additional conversation that you want to have with him. Obviously, I'm not going to relay the specific because they are protected by attorney-client privilege. And during the inquiry, Ms. Rodriguez related certain circumstances where Ms. Becker gave Ms. Rodriguez client advice and advice that conflicted with the advice that Ms. Rodriguez had given her clients. And as said before, even if the discussion is about public image or media or anything of that kind, that is also contained in the definition of legal advice. There could be two questions here. It could be that if this advice was given, then just what Ms. Becker thought was good advice, that she also represented Mr. Kelly, and a reasonable person could conclude that she was gaining their confidence and giving him advice that was designed to help Mr. Kelly, not necessarily them. Now, I'm saying that this is not reasonable person could conclude, and I think it is in the record that at least Ms. Rodriguez's perspective, I believe this is, let me just check with my law clerk. She paused. When the relationship was ended, they told her to send their file to Ms. Becker. So clearly there was conversation going on in a situation where when you representing one person and you want to find out what the witness have to say, that's fine, but they are being represented. That poses an ethical conflict. And not only all ethical conflict requires this sort of inquiry, or certainly that counsel be taken off the case. Uh-oh. Uh-oh. But in this instance, there is a plausible accusation of violation of the code. Whether or not that actually happened can be created in its own pressure on lawyers to refute the violation, to refute the accusation. So I just want to make sure with Ms. Haramati, I know this sort of a related issue to some of the other issues that have come up. But do you need any additional time to discuss this particular feature with Mr. Kelly?
Your Honor, we discussed similar issues. I would appreciate if I could speak to Mr. Kelly for a moment before answering the court whether I need.
Okay. Why don't we do that? So you don't have to do that with us all watching here. What's best way to do that? Take him to the back. Okay, let's do that. We'll be in recess for a minute.
Thank you, Your Honor.
All right. Recess is taken. Earl, of all, I know it's cold in here. It's either freezing or you're on fire. There is not a whole lot we can do about that. In my experience, it is better to be cold than hot. Anyway, I'm sure it will be hot in another day, but that's just the way it is. Let me ask Miss Haramati, have you had enough time to discuss with Mr. Kelly not just the conflict that were identified or potential conflict that were identified in this submission, but I guess I will say somewhat different by relating to what came up today?
Yes, Your Honor. Just with this additional time, we were able to discuss it significantly.
I see. I have, and have you discussed all those issues that were raised in the letter?
We spent time discussing all the four other issues that were raised in the government's, I think, the June 14th letter.
And in your view, does he understand those conflicts, what those conflicts are?
Yes, Your Honor.
Is he able to, is he capable of waiving those?
Yes. Yes, Your Honor. Go ahead.
That's you.
What? You supposed to say go ahead.
You got another one.
I said yes, yes, Your Honor, and you supposed to say go ahead.
No, yes, and then Your Honor.
Oh,
That's a different person.
oh, okay. I'm sorry.
It's a different person. I'm sorry. Okay.
Okay.
Go ahead. Go
Okay.
ahead.
Your Honor, before Your Honor begins the inquiry, as Your Honor pointed out, the government mentioned additional potential conflicts in its submissions, and we would ask that to the extent Your Honor has a concern with respect to doing a more detailed inquiry for the purpose of not discussing sealed information, the court would consider, so that the record is clear and the abundance of caution during the inquiry with respect to those other issues via sidebar or some other method for the purpose of making sure that the and for the as well as the interests of the defendant and the interests of the government to make sure that the record is as clear as possible.
I mean, I can do that. But Mr. Kelly is sitting over there at the table, so I'm not quite sure how that would work. You want him to walk over here and ask him over there?
If that's possible, Your Honor.
I think that's when we first met. Um, I mentioned that there were things in there that I think that the government had also agreed are there are not a significant basis to conclude that they actually happened. But the concern is that anybody that a lawyer might be concerned about making sure that it didn't get out or something like that. I can't think of the name of the case, but it's akin to Loyal
Fulton.
Fulton, right? Fulton. The lawyer was accused of something that's not true, but the lawyer may have had an interest in defending herself or himself. But that accusation, I think, could do without identifying the things that are that we don't think that there any basis for. I don't think that's necessary as long as we're making reference to, and you can point me to the paragraph in the letter. I can even have Cursio Counsel show that to Mr. Kelly because I know they have discussed it and just the Cursio Counsel has also advised that she's gonna go over all these things with him. I'm just going to, for the belt of suspenders, I'm assuming that as part of that conversation, you advise Mr. Kelly that the question isn't whether certain accusations are true or untrue. One of the possible issues is there's something, an accusation out there that concern is that the lawyer's interest will be defending. Listen, the lawyer's issue is defending himself or herself from accusation, regardless whether it's true.
Yes, we discussed that.
Does that sound sufficient?
Your Honor, if the government has an opportunity to hear the inquiry and then perhaps have an opportunity to be heard afterwards, we appreciate it.
I'm sorry, y'all.
20.
Hold on,
Okay.
20. I have to go to the restroom. Hold on.
Okay.
All right, sorry about that. Had to go pay the water bill.
Do
All right.
perspective want me to repeat my last sentence?
Yeah, she said, repeat your last sentence.
What? Yes, we discussed that. Oh, Miss Cruz Mendez part. Your Honor, if the government has an opportunity to hear the inquiry and then perhaps have an opportunity to be heard afterwards, we appreciate it.
Will you let me know? So let's get Mr. Kelly. I think if the council could give him a microphone.
That's you, Mr. Kelly.
You want me to be Mr. Kelly?
No, it's not Mr. Kelly. It's
Oh.
You said microphone, then you supposed to say Mr. Kelly.
Oh, okay. Mr. Kelly. You gotta do that deep voice, okay?
Okay.
Mr. Kelly, make sure it's on. Are you vaccinated?
Yes, ma'am. Is that deep enough?
I'm sorry, y'all.
I'm R. Kelly, y'all. Yes, ma'am.
So you can pull it over towards you.
Thank you.
Your Honor. You gonna be Mr. Kelly? Oh, okay, go ahead. You be yourself. Mendez.
Your Honor, if I could note one thing that may make this move a little more smoothly as you begin the inquiry. As the defense counsel noted, Mr. Kelly has some reading limitations, and so to the extent Your Honor references something in the filing, we would just ask that Ms. Harmati have an opportunity to speak quietly to the defendant so that it's perfectly clear.
So, based on what I've reviewed, Mr. Kelly, I have determined that Ms. Becker has potential conflict of interest in representing you. I have also determined that you can waive those conflicts if you are informed of what they are, and if you consent, you can continue to have her represent you. The potential conflict arise. One of them is because of the evidence that Ms. Becker had substantially contacts with potential witnesses and may have developed a relationship of trust with them, even though she may never formally retain as their lawyer. She has confidential obligation to them. Given the nature and the extent of those communication and the content of them, she would have a conflict if there were to cross-examine either one of them. So that's one of the conflicts. Related to the conflicts, conflict also, this is a question of whether there's an ethical violation involved in that. In those contexts, if there is an ethical violation or accusation of an ethical violation, the concern is, as I said before speaking with the government, the concern is that a person would be motivated to defend himself or herself from the accusation in a way that might keep the lawyer from asking certain questions and calling certain witnesses. That's what the concern is. The other conflict, which I don't think there is a factual basis for them, is the same question I've asked the Curcio counselor, Miss Haramanti, to review with you and advise you of all of those concerned. Now, the general issue here is that whenever a lawyer has a conflict of interest, it's a lawyer's best interest, and what is best interest of the client may not be the same. And so you have a constitutional right, as I have advised you before, to be represented by a lawyer who has no conflict. You also, within certain limitation, have a right to choose your own counsel. We also have a situation where you have two other lawyers, and so that's also something you can take into account. So I'm going to ask you a series of questions so that I can make sure that that you understand the conflicts that are, and that you are in position to tell me whether you want to waive them. So are you willing to answer those questions?
Yes, ma'am, Your Honor.
So, do you have any condition or anything that would interfere with your ability to understand what's happening here in court today?
No, ma'am.
Okay.
Wow.
Now, you are currently represented by Miss Blank Becker. Is that correct?
Yes, Your Honor.
And are you satisfied with her services so far in this case?
Yes, I am. He didn't understand because she said that you also have other attorneys, like they were going to help him, He didn't understand.
All right. Do you intend to go forward with Miss Blank Becker as one of your lawyers?
Yes, Your Honor. Wait, what line am I on? I'm sorry, I missed it.
Yeah, you're right. Number 15.
Oh, yes, I do, Your Honor.
And she has had, as you are aware, there is certain evidence that she has had sustained communication with potential witnesses in this case. Are you aware of that?
She should have broke it down and asked him what you understand rather than just taking, yes, ma'am, Your Honor.
And as I said before, listen to this, there are risks to being represented by a lawyer who has those conflicts. That has been raised in this case. So, to the extent there is an attorney client relationship, it doesn't have to be formal. to the extent that Ms. Becker gave legal advice of any kind to a potential witness. That means she owes that person a duty of loyalty, and she might be preventing from either investigating leads or introducing evidence or challenging a witness's testimony. That includes Jane Doe number 5 or calling any other witnesses Miss Savage, if she were able to rely on information that she received in privileged communication. Do you understand that?
Yes, I do, Your Honor.
Now, she also may have gotten some privileged information from either of those two witnesses that could help your case. But she can't disclose it to you because of her ethical duties. She couldn't share that information with either Mr. Canick or Mr. Farinella for the same reason. Do you understand that?
Yes, I understand, Your Honor. Lord have mercy. But you understand, Mr. Kelly.
She would, listen to this, she would also be prohibited from cross examining or doing any direct examination of any witness whom she had the privileged conversation, including Jane Doe number 5 and Miss Savage. Do you understand that?
Yes, ma'am, Your Honor, I do. No, you didn't.
Now, as I said before, she has a duty to loyalty to people that she have given legal advice to, regardless of whether they're a formal relationship. That duty continues even after the relationship ends. So she owes a continuing duty of loyalty to former clients or anybody to whom she gave legal advice. There is a chance that she could make decisions that consequently or consciously or unconsciously, that could influence how those decisions might be affect the people whom she owes a continuous duty of loyalty. Do you understand that?
She was saying too much. He won't understand. But yes, Your Honor.
Answer the question, please, ma'am.
Yes, Your Honor.
And then related to that, although, is the question of becoming unsworn witness, having given information from witnesses. But again, since you have 3 lawyers, it's that concern. One of the lawyers can take the witness. Do you have? I'm sorry. The other lawyers can take the witness, can do the examination. Do you understand?
See, by her saying, yes, I do, Your Honor.
Now, in addition to that, there are certain allegations. I think the best thing to do might be just to refer. I'm going to ask Miss Cruz Mendez. I think it would be EFC number 107, might contain that certain are in the right. June 14, 2021 letter, which is, I don't believe the EFC number directly is in front of me. That is okay.
June 14, 2021.
And I'm just going to direct Miss Haramati to that letter, in particular the second paragraph of 2, which, if you can direct Mr. Kelly what I'm talking about.
I will do that.
And related to the information in the paragraph following that.
I'm sorry, the paragraph following related to the unsworn witness issue. I believe the second paragraph on page 1, is that it? You want me to read that?
Yeah.
So the second paragraph beginning on page 1, which goes into the top of page 2, and as well as the first full paragraph of page 2.
You review those specifically.
We have. Your Honor, just one other thing. With respect to the second full paragraph, which is technically paragraph 3 on page 2, I just wanted to note that in addition to Jane Doe number 5, there are additional witnesses or potential witnesses named starting at the end of line 3 into line 4 that would also be included in the with respect to the sworn witness issue.
Man, yes, we have just said that.
Okay.
I think we did, didn't we?
I believe we've covered the unsworn witness. Thank you, Judge.
That's all right. So, specifically, the second paragraph on page 2. Mr. Kelly, have you reviewed the content of that paragraph? Is Miss Harmonti?
Yes, Your Honor, I have.
You understand what contains in them, correct?
Yes, Your Honor. Yes, correct.
And also in the paragraph on the preceding page, which I actually think we discovered the last time, but I also don't think there's much of foundation for that. That's also contained in a separate allegation. Ms. Haramonti reviewed that with you, not just today, but in your prior meeting, correct?
Yes, correct.
And again, that's just the general issue is that attorney who has committed unethical conduct.
You should have never been.
I'm not oh Lord. I'm not saying that anybody did, but the general question is that someone who has something unethical may want to hide that conduct, and an attorney who is accused of unethical conduct, even if that person didn't do it, may seek to dispel the impression that she did it or he did it. If the person did it, they may want to hide it. If the person didn't do it, they may want the accusation to come out, didn't want the accusation to come out. That's basically what I'm saying to you. In either situation, the lawyer could make a decision that aren't your best interests in order to protect herself or himself that the information from that information. So again, and I think I mentioned this before, a lawyer may choose not to call a witness to avoid certain kind of questioning because the concern is that could affect the lawyer's career. Do you understand?
Yes, Your Honor.
And the other thing is that a lawyer who is accused of wrongdoing or of that, some of that thing that contained in the letter may not be given you a complete, independent, and unbiased assessment of whether you should go to trial, whether you should testify, things like that. Do you understand?
Yes, I do, Your Honor.
Do you have any question about anything that we've talked about so far?
Of course he don't. No, I don't. I don't know what you're talking about.
There may be, and I identify a few issues here. There may be additional issue that comes up. Nobody can predict every possible conflict or issue that may come up. If later, in this case, there is more information that comes up or conflicts become more serious, I I don't know what this will happen, but it's always a conflict. I'm sorry. There's always a possibility that I may have no choice but to disqualify the conflict lawyer at that time. Do you understand?
Yes, I do, Your Honor.
Now, I explained earlier that the court appointed a respected member of our bar, Miss Haramonti, who is independent of this case. And her role was to advise you of all of these potential conflicts. And I understand that she has met you. Huh?
I'm sorry. Go ahead. I'm talking to my husband. I'm sorry.
Mute your phone. You're disturbing other people. Yeah, I apologize, people. I don't even know where I was at. Okay. I understand that she has met with you and advised you about the concerns that are raised in those submission. Have you had enough time to consult with her, or do you want to get additional advice or guidance from her? Don't hesitate to ask if you want it. You're not under any pressure to make this decision at this moment. If you would like, we can take a recess. You can consult with Miss Haramonti one more time about these issues if you want. I will give you an hour or so to talk to her to make sure you understand everything about it, because the next phase, so just you're prepared. I really want to make sure you understand what the conflicts are. So I can be at and so I will be asking you specifically to describe those to me, and then I am going to ask you just make sure that you understand what your rights are in connection to this. So I think it's probably a really good idea to take a half an hour or so to meet with Ms. Haramata and to make sure that you don't have any additional question. That is what we will do. We will recess for a half an hour. Before we do that, I don't know if there are any questions that either Ms. Haramata or the government wants me to put to Mr. Kelly before before you consult with Ms. Haramata. Hello? Ma'am?
I'm sorry. Nothing from the government, Your Honor.
Anything from Miss Haramonti?
No, Your Honor.
Let's recess for that period of time and then we'll resume. Okay, they're taking a recess. Y'all, all right, I want to read what you say. PDQ says she's lying. Mr. Kelly was always preventing from speaking that lie she made this up. Huh? What did I say? Mr. Kelly was always prevented from speaking that lie she made up. Huh? I'm confused. PDQ, what are you talking about? She explained where was Farinella for this part. Greenberg. They were right there, but they just wasn't talking. Yeah, Greenberg was leaving the case. Yeah, wasn't that call? No, that was not a call. Nope, that was the hearing. That was an in-person hearing. Is when Robert was there in New York at the hearing. That was a Curcio hearing. An abduction of a child. Okay, how do we know? How do we know if RSK was told to respond a certain way? How do we know if RSK was told to respond a certain way? This didn't really benefit him to keep her. Bree said she's always said that his lawyer would talk for him every time he tried to speak up. That was at the hearing. The hearing, usually the attorneys speak. But she was asking him those questions at the time. The hearings, the attorneys usually talk. Okay. Did RK know that Greenberg was leaving? Yes, he did. He knew Greenberg was leaving.
Can I say something, Sylvia?
Go ahead, hon.
She should have never gave him a choice, especially when she telling him that your attorney cannot talk for you. Your attorney can't do this. She should have took that lady off completely.
But you know what? She did say she was going to remove her if there was a conflict, but I don't understand why she didn't remove her.
And she said it was a conflict, so she should have removed her.
She should have removed her. We gotta because they said there was some parts where when there's an actual conflict, it's not waivable, right?
Yes. She should have asked him, "What do you understand?" Let him.
She did. She asked him. She did. She did. I'm gonna read it. It's coming further down.
Oh, okay. I want to see what he said.
Yeah,
Did he say anything?
He said something that she was like, because I think some people started laughing in the thing, and
See, he didn't understand what was going on.
She kind of chastised them, and she was saying that even lawyers may not understand. But she was in his ear.
Exactly. She probably said, no matter what she tell you, you need to say that you need to keep your me.
She probably said, "Oh, there's nobody gonna come to you. Somebody didn't. They never came and visit you. This person didn't do this, and this
I'm the only one been here for you.
I'm the only one been here for you. Don't listen to them." And I had to turn off these lights. These lights were bothering me. Yeah, somebody was in his ear. And plus, he didn't trust the other lady because she was new. He didn't know her.
And then all his attorneys that was there, couldn't nobody say nothing to them because they didn't know what was going on. They couldn't even look at the stuff that she had did, right?
Henny says but Henny, you're gonna take too long because you're gonna be printing and all this stuff. You're gonna take too long. T-Girl said she didn't break it down enough for him. That was the job of that attorney she gave him. That she was the one supposed to be breaking that down for him.
And still, when the judge was saying all that stuff, how he supposed to comprehend all that stuff that she was saying before he could say, "Yes, ma'am"? He just was agreeing,
But remember, that attorney was given to him back in June, and this is July, so she's supposed to have been seeing him and going through everything with him.
Well, nobody seeing nobody in no COVID. He was chained up and everything. She wasn't going to see that man. His attorneys weren't even going to see.
Yeah, no, but I'm saying she was there in New York. She was going. She wasn't in there to see him. Now, how many times she went in there, I don't know. Can't tell you.
Didn't New York stay on lockdown and stuff?
Not during that time. Not then. And then they had video conference. You could have talked to him.
That judge wasn't exactly saying that you should let this lawyer go no matter what. He wasn't understanding.
Mira, read what I just say.
Who are you talking to me?
Did you see what I just said in the thing?
Yes, ma'am.
Okay, look. Okay. Get it? Okay. I'm sorry, Tameria. I just don't get too quiet on me now. You supposed to be reading.
I'm here. I'm scared.
All right, let's finish reading. Where are we at? Where are we at?
We're at the when she said we're going on a break, a recess. So you at 10.
Okay, number 10. Okay. All right. Let me just ask Mr. Kelly, have you had enough time to consult with Ms. Haramanta about the issues that are involved here and about what you want to do?
Yes, Your Honor, I have.
Okay. Do you think that you are in position to tell me whether or not you want to waive your conflict of interest?
I believe so, Your Honor.
So, what I would like to start with first, if you need some time to speak with Ms. Haramana at any time during the course of this inquiry, I will give you as much time as you need. But what I would first like to do is just ask if you can tell me what you understand the potential conflict in general terms and what the risks are that are associated with those potential conflicts. All right, now this is your chance to tell the judge. You hear me? Slowly.
Here I go. Okay, thanks, Your Honor. First off, as far as Jane Doe number 5 and Miss Savage, I understand that as far as Miss Becker, Blaine Becker, it's hard to pronounce. As far as she's concerned, if there's a conflict of interest, I understand that if I waive, she will be able to question, but she will be very limited as far as questioning them.
She may not be able to question them at all.
And I understand that as well.
Okay. And so, in terms of that portion of it, of that fact that she may be limited in the things that she may ask them, do you understand that she cannot share any she cannot share any confidence that she learned from them with any other members of your team?
Yes, I do, Your Honor.
Now, aside of that, from that representation question, the appearance that perhaps she provided legal advice to them, there's a separate question in connection with that. She contacted them having to do with potential ethic violation, and whether or not they were committed is not the question. The question is, when a person is accused of that, when a lawyer is accused of that, it might make the lawyer make a choice. Listen to this.
Mm-hmm.
Does not benefit your best interest. Do you understand?
Yes.
Can you explain back to me? If you want to consult with Miss Haramada, let me know.
Just give me a second.
Sure.
Sorry.
That's okay.
I understand that if Miss Blank Becker talked to any clients that were represented by an other attorney, that she could try to cover that up to make herself look good instead of focusing on paying attention to what she should be doing for me. Basically, in my trial, I understand that.
And then there is a couple of other matters that we won't refer to specifically, but just for ease of reference, they're the items that Miss Haramada showed you in that letter. Do you recall those? What those were?
Yes, ma'am, I do.
Okay. In general terms, what is your understanding about the reason why that conflict or potential conflict could pose a difficulty for you?
Well, I think for one, they're rumors, and that's all they are to me. See, he understands. He didn't know that it was a fact, that those were facts, and that the he repeated. They say he repeated what the attorneys told him, that they were rumors. Wow, I didn't know that.
Not those attorney, that attorney. It was only one attorney, but I was questioning.
Oh,
one attorney. One.
Wow.
One attorney. Did you hear that? One attorney.
Mm-hmm.
She told him it was rumors.
It was rumors. Well,
right.
I think for one, they're rumors, and that's all they are to me.
Okay. Right. Do you understand the risks that even if something isn't true, a person could take the steps to make sure that the rumors don't get out? Let's say that. Do you understand that?
I understand that, Your Honor.
And that relates to what we just talked about, is an ethical concern. And you gave a pretty good description of what that is. Do you understand that this concern is pretty much the same concern?
Yes, ma'am, I do.
The final related question to the contact with the witnesses, although this is ameliorated by the presence of other lawyer, in the extent of which, having learned things from those witnesses, even putting aside question giving legal advice, a lawyer could put herself in the position of being an unsworn witness. That's the third related concern. Do you understand that? Let me have Miss Hermana explain it to you once more, and then I will give it a shot. Then we'll give it a shot. So she's having the other attorneys to explain it to Robert.
Just one moment, Your Honor.
Sure.
I believe we're ready.
Okay. So, do you understand this potential conflict? What this means?
Your Honor, when the attorney was explaining it to me, it sounds perfect, and I totally get it. I just don't know how to repeat everything she just said. Wow.
Wow, y'all.
You didn't
All
understand.
right. Let me do this way. By the way, these are not. This is when she start admonishing these other people around because she's trying to explain to them this is not easy. She says, "Let me do it this way. By the way, these are not easy concept for anyone, so I can understand that. So let me just first make sure you understand what counsel explained to you. Correct?
Yes, correct.
Okay. And the risk is, and it's a little bit subtle, but the risk is that if attorney has a conversation with a witness and the witness testifies is different ways at this trial, that lawyer can certainly question the person about it, but the lawyer can't say that didn't happen. This is what you really said, because the lawyer is not a witness. The lawyer is a lawyer. How did you do, Miss Haramana?
How did I do?
How did I do, Miss Haramana? Sorry.
That's precisely what Mr. Kelly and I discussed. What the?
What?
How did she?
Wait a minute, tell him who just said that. Tell him who just said
Miss
that.
Becker said, that's precisely what Mr. Kelly and I discussed. How is she discussing this with him?
But she wasn't. She said, how did I do, Miss Haramana? Why is she answering the question for Miss
Right.
Haramana?
Oh my God. Wow. She gonna jump in and say, Nicole gonna jump in and say, that's precisely what Mr. Kelly and I discussed.
So that's the reason the lawyer can't be a witness, because the lawyer is a lawyer. Is that clear to you? Is that clear to you?
Where is that at?
20.
Very clear, Your Honor.
Okay. So I want to make sure that you understand, and I think you do. You have the right to object to having Miss Becker represent you because of these issues. Do you understand?
Yes, ma'am, Your Honor.
Okay. After speaking with Miss Haramada and hearing what I have explained to you, and based on the advice that you have gotten from Miss Haramada, do you understand you still want to continue with Miss Becker as an attorney?
Yes, ma'am, Your Honor. I do.
Right there. There she go, right there. There she go. What did she say? She said, right at that moment, the judge should have said, who asked you? So now dismiss yourself, me. Do you understand? Listen to this, okay? She said, yeah, he do. Do you understand that by choosing to continue with her, you are giving up your right to be represented by a lawyer who does not have a conflict of interest? At least you have two lawyers who don't have a conflict of interest, but at least as so far as she is concerned, you are given your right to have a third attorney that doesn't have a conflict. Do you understand?
That part I don't. Come on now, Kelly, tell her.
You have two lawyers who are, as far as you know, don't have a conflict. You got Mr. Canick and Mr. Farinella. There is no allegation that anybody is conflict. Miss Becker is not your only attorney, but I want to be sure that you are giving up the right to have her represent you without a conflict of interest. Do you understand?
Yes, I do, Your Honor. Mm-mm. Oh, wait,
Okay.
what's that? It's that prospective juror.
No, that's Rob. That person typed the wrong thing in there.
Okay.
Okay, and that means that if you were to be convicted, this is the part, y'all, this is the part that's not good. That means if you were convicted at trial, you couldn't later claim that your lawyer, Ms. Becker, wasn't an ineffective counsel because she had these conflict or potential conflicts. Do you understand?
Yes, I do, Your Honor.
Is there anything else you need to have? Well, you know what? They said wasn't ineffective counsel because of conflict. See, okay, no, that doesn't. No, y'all. He could still be an effective counsel, not for the conflict, but for not being equipped. She could still be ineffective counsel. You know that, right?
Mm-hmm.
You see right here it says because you can't say she's ineffective because of the conflict or potential conflict. That's not the reason. She could still be an effective counsel for other things.
Mm-hmm.
Okay, we need to. What are all the reasons somebody could be ineffective counsel other than conflict? So she could still be ineffective counsel. Yes, thank you, Jesus. Thank you, Jesus. She could still be an effective counsel. Just the reason cannot be because of potential conflict or conflicts. That's not so she could still be because she number one, she never did a trial, a federal trial before. That's still ineffective.
Can I say something?
Uh-huh.
And wasn't she a prosecutor
Yeah.
attorney?
Mm-hmm.
She how she defended him and she I'm just saying, I don't know.
But that's not a reason.
Okay, I don't know.
What's another ineffective? Okay, I'm not sure. Perspective, me to the average person could see he had comprehension issue. She even acknowledged. Yes, she did. She acknowledged it. Judge acknowledged that he had a comprehension issue, and so did the government. The government even said that. The government even said that he had a literacy. Because she asked, because remember Mendez asked if the attorney could read it to him while the judge explained it to him. Yep, that it's right there, y'all. It's right there. It's right there. Okay, let's read the facts here, okay, y'all. Let's stick with the facts, right? Right, Tamiria.
Yes, ma'am.
Let's stick with the facts. Okay, where are we at?
One.
Number one, the next page, 47.
Yes.
All right. There is anything else that you need to have explained or that you need to consult with Miss Haramata
No,
about?
no, no, no.
Any other question from the government wants me to put to Mr. Kelly?
Nothing, Your Honor.
Okay, I think based on the record, we have established that Mr. Kelly is fully competent. No, I don't think so. Competent and capable of making an informed decision,
He's
that he
not.
has been advised by respective counsel, Ms. Haramanta, that his waivable of these potential conflicts is knowing and intelligent, and so I accept the waiver at this point. And I think it's fine to excuse Mr. Greenberg and Mr. Leonard, who I think is on the phone. Is that right?
Yes, Your Honor.
Yes,
Yes,
Judge.
Judge.
Are you are excused from representation in this case? And Ms. Haramani, you have the thanks and respect of the court for your efforts in this regard. I greatly appreciate it, and don't think we need to have we don't think we need to have Ms. Haramani spend any more time with us here unless she wants to. Okay.
Thank you. That was Miss Becker.
Mm-hmm. Thank you so much. All right, now listen to this. This is her talking. I wanted to address a couple of additional issues. I received Mr. Canick letter regarding some sticky points at MDC. Before we begin this proceeding, I'm sure that the government has something to say about it, but I did speak with Peter Lee, who gave me some answers to those particular questions, and I have a second solution for this problem. So I am going to list and what I have learned from Mr. Lee, and just bearing in mind that these I'm sure are well aware that certain restriction that what we can be brought to the facility. Oh, this is a time when they couldn't bring certain things, laptop and all that. Okay, that's it. That's it. That's all I want to read in this, y'all. Did you hear me? So you guys, no, you have not seen this. Okay. She says, no, you have not seen. That is what I was saying. She is saying he is competent. That is what I was saying with her saying he was competent. Oh. But he wasn't competent.
So Miss Hamata wasn't a therapist or a counselor, nothing like that, was she? A specialist.
Mm-mm.
Okay, well, she wasn't able to help him then.
Okay, I'm taking this stuff off my neck. It's crazy. He didn't understand it. I think because the other one was in his ear. He was not competent. He didn't understand it. I didn't think he understood it. But she said what she said, but then PDQ say enlightening. All right. But y'all. You're welcome, Shay. I'm about to get off. I just wanted to show you guys that part.
Thank you, Sylvia. It helped me out a lot to understand what was going on.
That's why sometimes it's best to go back to what actually happened in court, so we understand. Nope, she was just an independent attorney, did not specialize in helping those with comprehension or literacy issues. All right, guys, I'm about to get off. I got to get to work. I spent some time with y'all, enough time. I am so glad I was able to show you guys, and hopefully somebody will see what I was talking about. Somebody will hear what I was talking about. Somebody will understand. Hopefully the court will see what happened, and y'all got to do the right thing. Do the right thing, people. Do the right things. Do the right thing. Free R. Kelly. Freedom.
Do the right thing. Free him, please.
I need to play that song. Free R. Kelly.
It's free R. Kelly.
I'm gonna play it. Freedom. What in the world? Man. Lord have mercy. Oh, whew, Lord Father, it was so. Y'all do tell Jesus all about your trouble. Do tell Jesus. Guys, I'm telling y'all, this is some strange shenanigan. It's time to go back to the basic, guys. All right, but guys, we're about to hit the road. Perspective. Don't cry, perspective. Exactly, T-Girl said, reiterating what was said to him. Regurgitating what he said when those attorneys did not uphold the oath they took. That's what she said there. Yep, everything was very educational. It said all, let's get an understanding and pray. Yep. You're welcome, Shy. And I can make a decision even though it was obvious he is not. He needs psychological evaluation to determine whether or not he is competent. Please, people. For Nicole to speak up and say what she said over him when she was being asked and told him it was all rumors. Don't believe it. It's dismissed. Yeah. Yeah, because she's the one who told him. He said it was all rumors. Lord have mercy, Jesus. We definitely need to pray. So, I hope those who's in the bushes heard what was read today. They did not need to do all that. I just pray that Judge Donnelly go back and read these transcripts and hear what she said at the Curcio hearing and see what was going on and showing that they should have been waived because he surely did not comprehend what was being said. It's in there. Okay. Thanks for being a truth teller. I've learned so much about this case from you. Oh, Ashley, you're welcome. Competency has everything to do with IQ. Level, no judge or attorney can verify that God has Robert in the palm of his hand. Yeah. All right, yeah, I'm about to go. You guys have a good day. I am freaking tired, mentally drained from this. Tamiria, thank you so much for reading with me, because
You're welcome.
when you read this stuff back again, it's really sad. It's really sad that nobody really was there for him.
I know I didn't even want to repeat what he was saying. It was so sad I didn't want to repeat it because he didn't understand.
And remember how Patrick was saying that he would have removed himself. I mean, cut the losses. Just remove yourself from it. Let the man have a fair trial. And don't let it be about ego. Why are you still in it? All right, I'm about to go eat, y'all. I'm gonna go eat my salad. Y'all, I'm gonna just be eating. No, yeah. Hold on, let me play Peter's thing before I go eat my salad. Hold on. What kind of salad you think I'm gonna have today? Tamiri, what kind of salad you think I'm gonna have today?
A chicken salad.
I don't want a chicken salad.
Well, what's the other choices?
I'm gonna have all vegetable. I'm gonna make it like, remember the one I made, the hearty salad I made?
Oh yeah, that was beautiful.
It's pretty. It's very beautiful.
It was real pretty.
All right, I'm gonna go eat my salad after Peter plays. And
purple, red, yellow. Oh my God, it was beautiful. Green.
Yeah. All right, here we go. And I'm going to eat my salad.
This is for Robert Sylvester Galley. I can see you walking out through that open door. This is for Robert Sylvester Galley. Make your way and get out to the place where you belong. Just like you, the tunnel empty for the wicked people. Do 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 yo. Do 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 eh. Do 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 eh. Do 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 eh. America, free Macaulay, son of the Most High. I'm standing up for Robert Kelly. African, stand up for Kelly. Jerusalem, stand up for Kelly. Free Macaulay. I'm standing up for Robert Kelly. African, stand up for Kelly. Everybody, Jerusalem, stand up for Kelly. We are free Macaulay. This is for Robert Sylvester Kelly. God has heard your cry and has come to change it all. It's not been easy from your beginning. From your foundation, God is gonna walk it all right. Hey, you liars, will not you Kelly? To the betrayers, they're do 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 yo. Do 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 eh. Do 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 eh. Do 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 eh. America, no way, free Macaulay, son of the Most High.
Standing up for Robert Kelly. African, stand up for Kelly. Jerusalem, stand up for Kelly. Free Macaulay. Standing up for Robert Kelly. African, stand up for Kelly. Jerusalem, stand up for Kelly. Free Macaulay. Freedom for our Kelly. Freedom for our Kelly. Oh, oh, oh. Freedom for our Kelly. Freedom for our Kelly. Free our Kelly. Son of the Most High. Oh yeah. Do, 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 eh. Oh yeah. Do, 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 eh, eh. Do, 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 eh. America. Set them free. Set them free. Do, 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 eh. Set them free. Do, 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 eh. Do, 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 eh. America. Free our calling. Son of the Most High. Standing up for Robert Kelly. Africans, stand up for Kelly. Jerusalem, stand up for Kelly. Free our Kelly. Standing up for Robert Kelly. Africans, stand up for Kelly. Jerusalem, stand up for Kelly. Free my Kelly. Standing up for Robert Kelly. Africans, stand up for Kelly. Jerusalem, stand up for Kelly. Free my Kelly. Son of the Most High. Why idea? Set him free, oh. He's my brother. He's a good man. We all love him in Africa. He's touched millions of lives. Robert Sylvester Kelly, congratulations. You're out. You're out, man. Thank you, Jesus.